Hi guys, it's Kathy. I hope you're doing well. I hear some of you are snowed in. I hope you have eggs, milk, bread, and a shovel. And I hope you don't lose your power, because that sucks. Kelly, it's so good to see you. CJ, I hope you're feeling so much better. You should go drink some tea. I have a recipe for tea from some lady, some mod from Australia gave it to me. You should drink that. Oh, big spender. Mr. Moneybags here. He bought eggs today. She got a loan. I'm going to start buying my eggs off street corners. Hey, you want to buy an egg? 50 cents. I'm not telling you where I got it. Okay, so we're still in January 8th, 2024. Um, we stopped sort of right in the middle of that. So we're going to pick up where we left off.
I was never arrested, and
Okay.
there's only been one positive drug in my whole entire.
The discussion is based on
in evidence.
if you need further
Yeah, right.
specifics about this issue. So if you emerge from here today or tomorrow with still an inherent disagreement about the potty training, which he thinks this is just window dressing for trial and fodder for trial, as they're saying, they haven't really heard about this from you. But let's assume you have been telling them.
Practically, Polly, you got green yesterday. I think it was yesterday. I'm pretty sure it was yesterday. Although when I say the word yesterday, that's an issue. It's good to see you, though.
Is this order sufficient, or do you need something more to empower you to speak to these
Just
individuals?
joint legal is what you're pretty much saying.
Okay, but
right?
what-
So
what
that-
would
that
you-
gives me the power to do what I need to do, honestly.
But it kind of doesn't give you guys the power to do what you want to do
Right,
if the other doesn't want it and you don't submit it to the specialist to decide.
it becomes our responsibility, and it becomes my responsibility, and I'm willing to take that responsibility.
Okay,
To
so
be
I
honest,
expect to see
I
more
heard
open
everything you said.
communication.
I just don't know what specifically we're talking about. It sounded to me like we'd be talking about, like, my client saying, I don't want her to go to occupational therapy, and Ms. Hurd saying that she does. That would be a legal custody dispute.
Right.
I'm just not understanding what we're talking
Well,
about.
he's saying it's fine. He's saying it's fine, right? Right. But we already know, no matter what happens here, they're walking, now, maybe she sent them 218 notices, maybe she sent them none. We already know, we're walking out of here with her saying, Ashley needs to be potty trained more aggressively, and Dad says, hey, no, if you had been dealing with this like I am, dealing with all the experts, people in the educational realm, you would know it's a more gradual process. So until they're in
I've had
the
that
same
before.
room with the same therapist, this nonsense is gonna continue. And that's what it is, nonsense. Because if someone says, no, it's not nonsense, I'm gonna climb up on my soapbox and say, it's my legitimate constitutional rights and concerns. And I'm saying, here's how you can exercise those constitutional rights by being in the room with the expert, not pointing fingers at each other. It gets us nowhere.
Sure.
So he's gonna
Fair enough.
invite her.
All right, guys, let's get Nan screaming at the screen.
Not to say you're able to come to any appointment, but when he sends that deal every other week, he'll say, and that's the 7 matters that are set, or the 4, or, and of course, as usual, you are more than welcome, and I encourage you to attend. Kill each other with a little kindness, takes the fight right out of the other side of folk. Now, are you asking that, maybe he has his wife communicating, his girlfriend or wife, I'm sorry, your girlfriend?
Fiance.
Okay, maybe he has her communicating with you because he feels that that's a better combination than you and him. But if you feel that's not the case and you want to communicate directly with him,
open, Your
you
Honor,
need to tell me.
I'm open to working with whoever, if it's best for her, I'm open to working. I've asked him if he wants to go to therapy,
Okay.
to family therapy, I've asked him to meet up so that we can start being good co-parents. That's what I wanna be. I want
There's actually no chance of that today. Don't worry.
his family in my life. I invited him to church with me. Like, I want to move forward as a blended
I'm
family.
gonna force you guys
That's
to
what
get
I
along.
want. That's
You
what I want.
you will
'Cause
both
that's
be
what's
forced
best
to
for
get
her.
along,
She
and
needs her
you guys are
dad.
gonna grow up in a big hurry.
She needs her dad, and in a blink of an eye. She's grown up in 2 years. I've missed it. I don't want to take her away. she loves his girlfriend. I don't wanna
Okay.
take her away, she loves her stepbrother.
Who
But
would
she
you
also
rather-
loves
who
her
would
other
you-
family that she doesn't get to see her
Who would
brother
you
with me.
prefer to communicate with? Both? Him?
You know what,
Her?
if whatever is best for her, I'll
You brought
do
it up
whatever.
and you complained that the
If Carrie
girlfriend
is willing
was,
to talk to me, I'm
you
willing
said
to-
she was
I'm
obnoxious
willing to do
toward
it.
you. That may not have been the
I'm
term
willing to
used.
move forward. If she's willing to move forward, I'm willing to move forward.
He'll say move forward from what? Cause he'll tell me, okay.
Let's
Do you,
forget
are
the
you
past.
comfortable,
The
do you
past is the
think you
past.
and
Let's
mom
move
should do most
forward.
of the communicating, or is it easier with
Well,
your
I
parents?
believe she can communicate with Carrie, and because Carrie is involved a lot in Aslan's life, and if something needs to be said or happened, Carrie should be able to reach out to her, and she should be able to reach out to Carrie, and vice versa.
We're getting
Or do
along
it
Okay.
briefly, and I would love to continue that.
Are these mostly by text or verbally?
What I,
Well, I haven't communicated with Carrie in a while, but I'd be open to what,
When you communicate with him or her, is it usually
It's
by
text,
texting? Oh, it's,
text.
okay. So then it's pretty easy to make sure we're being civil.
okay.
And the court can require the family wizard, so if need be,
That's
I can
what I was
review,
gonna say.
I can
That
review the
makes a lot of sense.
communications.
And I don't have a problem with that. The only reason why I wanted to go with our family wizards, because Carrie
Okay.
can
I
have
agree
her
with
own, her own account, so I know who I'm talking to. But talking parents, they don't have a third party account.
That's
so
correct.
I don't know
You're
who I'm
right.
talking to.
I think
That's
that's
the
still
only
the
thing I've
case.
ever asked, so I'm willing to do our family wizards so that we can both.
Yeah.
I'll agree to this.
Yeah,
These things
much
are,
ado
these
about
things may
nothing,
not be
Judge.
important to you, I get it, but they're important to me because I think it saves
You're
us
a
a lot
wizard,
of
Harry.
time
Have our
and
account,
effort.
and then we
Me,
know.
in
That's
that sense,
fine.
what I'm
I'll do
saying
it.
is, Judge, we're talking about facilitating communication.
Right,
If I have a client, for example, who is not great at typing and has a brother or a grandmother or a significant other that is, and he stands over the shoulder and
Just
says,
put his name, but that's
this
fine.
is my point. So
That's fine.
it's all like, I think this makes a ton of sense, some type of an application makes a ton
Someone
of
else can
sense.
compose it for him, that's fine.
Something else, something that is an application that makes a ton of sense to store all this. I give it
Yeah.
right.
You're right,
It-
okay, good.
And I don't mind if our family, we
Well,
should get her in our
so
account, we
for
can do
the
that.
record, my client has been on Talking Parents because he's been paying for it since Your Honor ordered it. She never did, but we will
Well,
once
she-
again,
okay.
Judge, we will once again accommodate Ms. Hurd and switch to something else, Judge.
I'm asking what's best for my daughter, like, I don't care about me, I don't care about what's best for him or for me, it's for Aslan. We need to move forward for Aslan, please, can we do that?
So, Judge. all I
I'm
need to
begging, like, I'm
understand is
begging. Just
Oh, you
move
don't have
forward
to
for her.
worry. So we've agreed on joint legal custody, we've agreed on,
Our family was.
over, family wizard. Looks like we're,
Thank you.
it looks like overnights are not gonna be a big issue, so the main dispute is just who should have the main cut of the pie. We have agreed on how we're gonna handle these developmental
I'm willing
disputes,
to have an open
which
discussion with
means,
that, if they're willing to
which
step
means
outside and
the
have that.
experts, the specialists make the call. They decide. We're not gonna substitute our judgment to people who gave the whole.
record of everything that
Right.
goes in and everything.
Right.
I just don't know what we're talking about.
And what we're talking about is in the event that this is occurring and it's not just
Right.
stuff someone's pulling out for
Sure.
court to bloody someone else up. In the
Right.
event it has any legitimacy, do I know if it does? I'm not saying it does. But I have to operate from a presumption that if someone's presenting a problem, I provided enough initial credibility to the point, if it exists, here's how we're gonna solve it. It doesn't do good to just say it doesn't exist, and then the problem will persist if there is one.
He's still making me a sandwich.
Forgive me if I'm
So
not
it's
being
to
fair.
be proactive.
I'm not saying, turning blind, I think it doesn't exist. What I'm saying is I know he's first made some allegations. I understand those exist. I'm just
Right.
saying, if we read the terms of joint legal custody into the record, which I'm happy to do, or we can email it and print it and it can be entered, right? That gives both parents every single ounce of information and authority to engage on these issues that they need.
Right, but, and since they have a particular developmental dispute, I kinda want us to help them is, what would this look like in real life? That's all. What level of cooperation do we expect to see? And I think you're right, we can dump this issue, but is Dad basically saying then that he's not been receiving emails or texts disputing the developmental benchmarks on the potty training? That he's not, hasn't
Judge,
received,
what we've received are the same things you've seen in pleadings.
right?
That he's abusing and neglecting the child, the same things that she told you in court last time. She's neglecting the child's dental care, you said how. She told you because the child had decay in a cavity on a medical billing,
I
and you
didn't
said,
know.
and you said,
I didn't
but
know.
that's simply evidence that he's providing medical care. So I don't know, again, it's very hard to engage with something that, you know, isn't, there's nothing to support it, it's just claiming that my client's doing a thing. And so what we did, as I said, we went and got all of the records. She's had all of the records for more than a month.
So where did we go?
Technically, it's my dog. My dog. Because we got married a couple nights ago. And I get the dog. See the dog? Look at the dog. Oh my gosh.
Or can we do a joint
I
custody
understand.
situation?
Well,
Yeah, Ms. Hurd
apparently
would
we don't
like-
have an agreement, so we'll take
She
testimony.
would
and
like
see what
very
we-
much, Judge, she would like, we have a joint legal custody, we have joint legal custody
No,
week.
I mean,
I can read the specific terms in the record. What I'm struggling with, Judge, is that we all wanna move forward from here, which is wonderful. But we had a trial. The trial had 56 exhibits into evidence. Those evidentiary exhibits wound up in an order, and that's where they are, right? And the court wanted
And
additional
the
findings.
court did make
relative-
findings on those as to that period of time, and they
Absolutely.
remain in the record.
Right, so I guess I'm just trying to understand, you know, and I came here.
Sort of an update extrapolating from that date forward, basically.
From that date forward, what we have is my client caring for the child without incident, the child seeing all of the physicians and doctors, and Ms. Hurd desiring more and being frustrated at the process, and I understand that.
It's January
But she's
8th.
also identifying that apparently you guys are saying it's totally false, and I get it, that she keeps reaching out to me, keeps blowing it off, about the development. Well, it's a big issue. The potty training, but he's saying he's handling it, and maybe I was, so, since she didn't specifically tell me what it is he's not doing, I can hear it in testimony, or maybe we don't need to hear it, since they're gonna be meeting with the same specialist, or at least she'll have the right to meet him, the specialist.
absolutely.
But this issue won't be entertained anymore if you come back to court and complain about these benchmarks not being met developmentally, and he shows me
Impossible.
the
No one is.
ultimate syllabus where he says, here's
So
everything that's
crazy.
going on for the next 2 weeks, and you don't avail yourself to get in the same room or the same appointment to hear the same information. And I'm sure you will, so I'm sure I don't have to worry about this, right? But if that did happen, there wouldn't be any much sympathy or credibility to that
and
position.
you're right, like, that would be on me.
Okay, so,
I'm willing to move forward, I want what's best for her. I'm willing to negotiate. Yes, I asked for a certain thing, am I gonna get it, is it right? I don't know, but I want what's best for her, and I'm willing to negotiate. I've always been willing to negotiate.
before we start with the testimony, I'd be more than happy to give you guys a few minutes to, I think
fine with
Mr. Friedman, I tend to agree with him. I tend to agree with him, that's probably a waste at this point, we just need to dive into it. But if you really are overbrimming with optimism that a discussion with them may get us somewhere, no problem, I can excuse myself. If it becomes useless after 90 seconds, he'll have the marshal send for me, but if it goes on 5, 10, 15 minutes, it means some sort of progress is being met. I don't think that this exercise is worth doing if you tell them to jump immediately to giving you main custody, or even 50% right off the bat of the time. I feel that from what they've made abundantly clear, I'm not sure that would be, you may work to that over the ensuing months, a half and half arrangement, but if that's what you're seeking, you probably have to wait for a final judicial order after all the evidence, and we'll see where we're at, because I don't think, speaking for them, I don't want to, but is that a fair statement, that if I walk out the room and she either, well, obviously if she demands custody, we know where that goes, but even if she wants to jump to an immediate 50%, he would, from what has been made clear over here, it's way too premature from your perspective. That
That's
it's a nonsensical conversation.
And I think it's not only premature and nonsensical, but I think given the remand given by the Supreme Court, it would be wildly inconsistent with the record.
Right, unless we have a clear stipulation. Then
But Judge, there's just been candidly, Judge, there's been no ability to ever have these parties get there.
Yeah.
Because I think, Judge, and I just would like to just.
No
make
one's
one
really
point of
sat
that.
down with them.
There's one point I'd just like to make. At no time, Judge, have you heard in any of the hearings an acknowledgement of how we got here, right? And I think that's the first step in my, and this may be me being social sciencey, But that is the first step to move towards anything like what you're talking about. We have to not be trying to constantly prove that Mario's wrong and bad. We have to recognize that we got to where we got to based on a myriad of actions that we engaged in, right? But that's never what we hear. So the short answer to your question, Judge, is joint physical custody is absolutely not something my client would be agreeing to today. Not something my client believes is consistent with the mountain of evidence already in the record and whatever else has come, since that hearing, nothing in there would support anything like that.
Okay, hearing what they just said, do you
But-
still want to take an opportunity and speak? If it doesn't go anywhere, he'll just.
I'm not 100% sure. I know I like asked that question out loud yesterday, and then the judge sort of said, and about the drug test, but I don't remember if he said she's still testing and testing clean. I don't know.
Call for me and send me back down. Do you
But
want
I
to
think-
try and have a conversation? Because you guys know your schedules a lot better than I do. She's willing to try. But you did hear everything he said. I'm not saying
Right,
agree
but
with
if
it or
they're
argue
willing
against
to
it. But
work
you did.
towards
They
that,
said-
realistically, I would be.
We're always working toward that,
To that.
hopefully, in
The
an ideal
standard is
case.
Romano to work
So
towards.
I'll excuse myself, but it is so true that, and I remember at a relatively early age being mystified. How come everyone says step one, whatever the problem is, acknowledgement of the problem is so difficult? I said, geez, steps 2, 3, and 4 sound so much more involved, so much more abstinence over many months, and so much one needs to do in terms of therapy, behaviorally. Why is this one step just saying, yeah, I have this problem? Doesn't make sense that would be much more difficult than all these really labor-intensive steps. But then it turns out the experts knew what they were talking about, because that one step, when you first hear that, like as a teenager, you say, why is just saying, yeah, I've got an issue and I'm gonna acknowledge it and stop blaming everyone else? Why is that so difficult for people? When you look at it, well, steps 2 and 3 and 4 that you say you're willing to do is a year of therapy and this and that, and this that takes 5 seconds is more difficult, but because it's really, it seems simplistic what we're asking someone to do, but it's really profound in
I
a
think
human
you
nature
know,
standpoint.
no, Judge, I'm always happy to engage
Okay,
in a
perfect.
conversation. I just, under those auspices, we can talk about it.
She heard what you said, okay? Thanks, guys.
Thank you, Judge.
No, this is the private discussion.
She in fact did not hear what they said.
Back on the record, or do you want to mention anything off the record? I just want to go right back. Okay, we'll go on the record. Is there any progress to report?
Your Honor, I believed there was, I believed I was very clear in front of everybody as to what we were willing to negotiate around. I'm not gonna go into the details of it, misheard. Maybe there was some miscommunication, but it seems that she did not hear what we had said at that time and seems to think the only deal she would take would be automatically like a guaranteed time in, let's say, 90 days that she could have joint custody, and that's not on the table for us.
I was willing to negotiate with them and do the tier project that they said, which was fine with working up towards a joint physical. Because that's what I've had, and I had primary of my daughter for 5 years. She responds well to me. But they said no, that would not ever be an option. I got it. If it wasn't today, I was fine with that. Let's work towards it. And he indicated that there is no working towards it. So I'm not gonna just take it off the table indefinitely.
So if I can make.
My daughter needs her mother, and so I'm willing to work with them, but I'm not willing to give up my parental rights. I'm not willing to do that right now.
If I can make it clear, just.
Maybe I just don't deserve one.
Heard what I said. Certainly nobody is taking away from rights. In fact, my client stipulated to restore Jan's legal custody rights that you didn't have under the terms of the decree. Moreover, nobody is looking to take the time away from your daughter, and I never said anything other than there wasn't a world in which my client was going to stipulate to joint physical custody as a certainty. Certainly, as any case progresses, the court always reserves jurisdiction as to child custody matters. And if you got to a place where you felt circumstances warranted bringing it back in front of the court for some
I feel
reason.
like I have enough
then you
evidence
could-
today to show that I can get joint physical.
Okay.
I do have enough evidence right now to show I have I have progressed, I've admitted to what I've done the work, I've done the hard work. I've been released from my therapist and my doctor, I have the lab notes, I have everything I need to show. I put in the time.
Drug
I did
tests?
the diligence, and I did the hard work, and I've accepted responsibility, and there's no reason that I shouldn't have joint custody, because I'm a far better person today than I was 2 years ago, 3 years ago, and I will continue to grow, and I can show that. The records will show that, and my witnesses will show that.
Your Honor, Ms. Hurd is a pro se litigant, so I'm not here to give her legal advice, but perhaps I think it would be instructive to make sure we understand the nature of what Ms. Hurd is articulating in my ears sounds like the types of claims a parent would be making where they were seeking to modify custody, but that's not what we're here for today, right? This is a remand.
Thank you, Linus. You look so pretty, so big there.
And even on the findings, on the evidence that was submitted that Mr. Friedman was talking about, they're not sufficient to make a finding for sole custody and to find me unfit. I would like him to show.
Well, that was
it
to
where
the
in
point of,
record.
sole legal custody, and physical custody, there wouldn't be sole physical custody, but someone, there would either be primary or for one party or joint physical custody, obviously. Now, so we do agree, though, that since it's a little not totally clear what our starting point is, the courts, I don't wanna say treat it like a case of initial impression, there's too much water under the bridge for that, and too much that the court has to acknowledge in its findings, et cetera, historically and procedurally. With that, with those large qualifiers in place, the court would be walking through the general, the statutory standards, and presumably would be starting on a best interest level rather than a modification level per se. I mean, I know it's a little tricky in this case,
Right.
whether it's really a modification or
What I
whether
mean
we're
is-
kind of starting as a equal footing.
And that's what I'm trying to focus.
Yeah.
I would say, I
Right.
vehemently disagree from a legal perspective that it would be equal.
The last thing I think of when I see Linus's picture is aunt. I think of many other things. Nurse, never mind.
footing. And what I would try to say, you may disagree with me, Judge.
It's a little unclear to me,
To
to be
just
quite
make-
blunt.
To make the record clear, since Ms. Hurd has decided she wants to go forward with trial, and obviously that means that I have
I
to
don't
make.
want to, I want
Well.
to, but I want,
Very tempting, Caddy. Very
I'm
tempting.
willing to compromise, but I don't feel, I feel like there's enough grounds, and I've shown that, and that's, I've shown you.
It
and I've
sounds
shown
like
your
they
client that-
didn't have an objection, and in fact encourage you to be expanding your time, et cetera, but they don't want a situation where they're locked in where 90 days or 6 months it automatically progresses to joint physical without any further reflection
Would
on
there,
anything.
could I ask a question? So, say we did your tier.
Pardon?
Say we did his tier, then am I stipulating?
Well, I don't know what they offered, so I really
Okay,
don't
but-
know.
Say I did your tier, you're saying you're not going to guarantee me joint physical, but then I feel like if I stipulate to that, I'm compromising my rights to potentially obtaining that right now, and then I don't have the option to show the judge again what I do have and where I have come from,
course
because
you do.
now I've sacrificed
Of
that.
course you didn't, no. You always have the ability to say, even though, you always have the argument, even that I compromised last time, I thought I had enough then for joint physical, I definitely think I have enough now, but in the interest of proving to everyone concerned that I can handle this, I mean, it's all on, you wouldn't really be waiving anything concerning that.
That's
Now,
kind
the
of
problem I was
what
struggling with is this burden. That may not, it could be a case that doesn't make much difference. Which burden, or based on, which,
And this is
which,
why-
but if it reverts back to, it seems to be you correct a remand for better or different findings, particularly on legal custody. It didn't seem to say tear it down, start from scratch and nullify the whole
This
hearing,
is-
which
this
means, if you look at it that way, and then she does have to meet change of circumstances burden. If it's a total do-over, which I didn't interpret it as
That's it,
being,
Judge.
and I
that's
didn't
what I think.
interpret it as being, but it is a little confusing.
I feel like it's a combination of the two.
Maybe, maybe.
With all respect to Ms. Hurd and to the court, I think it is abundantly clear when you read the appellate court decision that the findings that were made are undisturbed, that the evidence in the record was undisturbed, the custodial designation is undisturbed. What they wanted was additional findings with specificity from the court, mostly, almost entirely. The additional thing they did is they vacated child support arrears. That's the only issue, Judge, that they took their hands and said, we're wiping that out because there was an offset for the cost of supervision, which Ms. Hurd didn't pay. But regardless, right, when it came to the rest of that, that is the opinion, right?
I mean, that's how I
what-
interpreted it
so-
as well, but I think to be on the safe side, I am gonna operate from an assumption that it was set in stone at that time of the primary and that she is the higher burden, but then I'm gonna rule on as a protective mechanism, which the court does from time to time. If the court's erroneous in that and they do start on a best interest standard, walk through that and determine whether the results would be any different. If the results are different, then we do have a big problem as to which standard. If the results are the same, then it's hard to say, you
I
know.
tend to think they're going to be, but I do think from the legal perspective, and since we are all concerned about the record because of the potential for appeal, which we've certainly already seen in this case, I do think that
Thank you, Bren. That's what I wanted to say.
it's not as though the Supreme Court or the appellate court said, oh, there was never a trial. None of that ever happened, right? That is absolutely still there. It just simply said, give us additional specific findings. Really, Judge, and I told you this last time, I think it's very, very reasonable and fair of you, because that's who you are as a judge, to hold these proceedings. But I think there's a lot of judges who would have simply issued a written decision consistent with the appellate court, and we wouldn't be having these proceedings. So, and I appreciate that you've given everybody the opportunity to be here, but I think it's very, very clear to me from that opinion that that's where we are. So if Ms. Hurd believes that based upon all of that, you know, that there's, you know, candidly what she's talking about is trying to modify, right? We can't just ignore the circumstances that presented
But I
themselves
don't
in the
agree
order.
that to have it ever have a.
Yeah, I understand, and I understand what you're, and I understand what you're indicating, and I do, and a lot of courts would have taken the action you take, and we get into that area of to what extent do we just rule on what's before us, or in this field, what preemptive measures do we, because if these two are left with the same conflict, the same parenting problems, this is gonna be endless, and he's gonna be spending tens of thousands he doesn't have. Just like this whole thing about potty training. If no one wants to have a sensible dialogue as to how, if neither side, or particularly the one side, didn't understand, it's not a matter of what we say or think, it's a matter of getting the parties into the same room with the specialist and follow those marching orders. I'm just hoping they take something from this, in the sense of conflict resolution, and I don't mean to be blunt, say it doesn't really, well, I will be that blunt, doesn't really matter what the parties think of a specialized medical or developmental issue if they disagree. It is in the hands of the people who've spent their entire life studying these matters and dealing with the child. Now, I do think that the path of far less resistance should have been taken, would have been 1,000 times more effective. And usually these appeals aren't entertained until they say, did you try and obtain a rehearing or a retrial? Because the court indicates...
Kitchen scissors are still in the kitchen where they belong. These are my desk scissors, so I can just cut little things.
It was extremely very open to, anytime someone doesn't appear, it's very open to a motion explaining why that situation is, and the court liberally reopens the matter and lets them argue. Does it always lead to different results? Of course not. Sometimes it doesn't, but at least that was available, and that's wasn't taken that way. Instead, all this time was invested. Plus, a lot incurred attorney fees on his side, so, you know, I think a simple motion on some of these issues may or may not have been effective.
I think I said that, Judge,
Right.
9 months ago.
Right, yeah.
So I 100% agree with you. Ms. Hurd, you seem to be asking me a question. If we're in the context of settlement, as I said, we proposed a schedule that over a period of 3 months expanded your time in what I thought was a very, very meaningful way, restored your legal custody. I'm not trying to prejudice you, Judge, I'm just speaking.
No, I understand.
And so what my perspective is, and it's consistent with what I believe to be the status of the law under the remand from the court, is that wanting to then bootstrap that into a date certain where you automatically get a custodial designation change, I'm unwilling to agree to that.
That's
The
what
court
the-
absolutely reserves jurisdiction. If you feel at some point in the future, once this matter is resolved. and
Me
the
neither.
handled and the case is closed, if there is a sufficient basis under the law to file a motion for that, I'm not trying to give you legal advice, that's the mechanism. I wasn't telling you,
No,
You're
and I
never
And
don't-
by the
gonna
way,
get
that
someone.
might not even be necessary, because if things are really going swimmingly, and you contact them 6 months or whatever down the road, and Mr. Friedman advises his client, everything seems to be going well, do you really wanna spend tens of thousands more and a lot of stress and headache fighting this? Who knows?
Mine almost never touch food, but sometimes they do. But they're my kitchen scissors, so they're allowed to.
I mean, because most of the time, that's how these things end. It's no guarantee it would here, so they're trying to protect his client, because he doesn't know, there's no guarantee it's gonna progress that way. But law of averages, from what I'm seeing and observing, I think things are gonna go really well, and you may be in that position a few months down the road, but they gotta protect themselves in
I
case it's one of those
understand,
cases
but I feel like
where.
I'm in that position right
Yep.
now.
But just, there are, and I tend to think that you might very well be in a position, if not now, then in the relatively near future. But that's why these exercises I have beforehand are very informative. The fact that I couldn't get you to understand that you think it's reasonable to just say, take my word for it on the developmental issue, don't listen to anything he said, and the fact that I had to kind of fight you to acknowledge what's painfully obvious, effective parents who who are gonna co-parent and exercise custodial rights on a 50% basis, and as you say, then by extension, make a lot of these appointments. The fact that, and candidly, he didn't, it took I had to question him, and this wasn't part of the record per se in terms of testimony, and I had to explain it a little bit to him as well, but I think he gets it. The fact that there
That
was
makes
some
the most
resistance
sense.
to that dialogue, when you should have been overjoyed to say, I want to be in that room, I want us both to understand. You need to be open and really delighted if the specialist's going to speak to both of you.
I have a white board for my chicken. I have a red board for any of my red meats, and I have my green board for all my veggies or fruits. Cutting boards.
And explain what needs to be done, even if it's not your preconceived notion. I don't want too much of this to be colored by, you want something because he doesn't, or vice versa, you don't want something because he doesn't. I think there's a little bit that going on from both sides. It's a kill the messenger type of thing. I think you'd be really open to things that are maybe coming from the specialist because they're coming from him or his fiance, whatever. There's this wall of resistance. And the fact that I'm just stating the obvious, which I must misunderstand, you because you must know that I'm powerless to just say, yeah, you're right, this child I've never met should be progressing at this level. The fact that you even went to the trouble of speaking to a specialist or expert, and this concept is foreign to you, that you both need to be speaking to that person and following their directives. And if you both
Thank
agree
you
that
so
person's
much,
really out
JK.
there and
Thank you.
let's say, and you're not interested, then you can go in some other direction. So you, not to beat this dead horse any further, but you do understand that I expect both of you, if there's a dispute, to submit it to the specialist or expert, because anything else would be ludicrous. You understand that, don't you?
Right.
Okay. Okay. Now, so I guess that's kind of where we are. Now, I don't know if it helps, but as far as the whole business about disclosing settlement offers, I understand that while parties are trying to negotiate a case, let's say a financial case, and they're going back and forth for months, that information understandably should be protected. But when we get at this point, we have to understand, number one, that rule is mainly to insulate lay jurors in jury trials from being tainted with information. Well, he must be liable for the accident, or he wouldn't have offered us $40,000 to settle it. And number two, it makes no sense to say, we're protecting the settlement negotiations, when the first sentence from each party's opening argument is, here's where we think this should wind up, and that's exactly what they would have just obviously proposed. So I think we don't need to be too cagey or concerned or gun shy about that in my estimation, so I'd be delighted to hear.
I'm happy to share my proposal with Your Honor. The only thing I would ask on the record that we do a canvas is just make sure there's a conflict waiver only because of the appellate history of this case. I
Sure.
can tell you my client
Sure.
will waive any conflict that might arise. You know, we don't believe there is one in sharing that with you, but I think it would be
Yeah.
important that Ms. Hurd acknowledge the same.
Right, you have to be, you can't use this issue that I asked you what you offered, and you willingly told us, and then you say later the court shouldn't have asked. If you feel that way, then don't tell us, but I just think it's something that's almost borderline nonsensical to get concerned about in this context, because the first sentence you're both gonna tell me in your opening arguments, or your testimony is, here's where I think the schedule should be, and here's when I think it should change, and here's what it should change to. That's gonna tell me essentially exactly what you guys were discussing, so it's up to you, if you wanna tell me where you think them. Now, if you are somewhat concerned about this issue, we can probably handle it just in an abundance of caution with the opening arguments. You don't have to phrase it, here's what I offered them, you can just say, here's what I think should happen. Maybe we'll handle it that way, that's fine too. So that said, Mr. Friedman, we've heard this various dialogue and Q&A and discussion from everyone. So the opening arguments from each side will probably be pretty to the point, just
No,
as to
they won't.
what should the final ruling be as a result of the evidentiary hearing, I suppose.
I would agree to that.
Okay.
Let me just make sure I understand. Forgive me, Judge, I'm not trying to belabor this, it's just because of the way that this has transpired over a period of time. I said I am happy to simply share with the court what I believe, what
Okay.
I'm willing to agree with, but obviously, I just wanna make sure that you're okay, that that's not an issue, that we have this conversation, then we all of a sudden reverse gears and
Right,
start
and
the
if
trial.
it
there's
is a
some appellate
possible issue, then we'll just phrase it not in terms of what you guys said when I wasn't in the room, but what you think should happen now, that's fine.
I can agree.
So in terms of opening remarks, which from your, and it probably doesn't have to be lengthy at this point,
So then, but I'm not-
what is your side asking, what does your side believe the evidence, who's being offered to testify,
Well,
and what's, at the end of it, what would you be suggesting the rulings are?
So, do you want my entire opening argument, which is not what I think you want, or would you like me to simply say, because it's not, to be fair, Judge, what I believe the evidence necessarily would support, is what my client, I believe, is willing to do in the spirit of cooperation.
Fair enough,
okay.
if we can just deal with that.
Sometimes.
like real
He
surprises
is,
are being
absolutely.
made during the testimony and evidence, which it could be, what is your, as you're sitting here now, what's the likely relief that you would, and it can always change, but likely relief you'd be requesting?
So without waiving my ability to make, if we do get into a trial, a full opening and discuss the various
Sure.
ways that I think that needs to happen, what we would be willing to do to resolve the case, if that's okay, if I can say that, resolve the case today, I think we're all on the same page,
That's fine.
okay? We've already told Your Honor that we would stipulate to joint legal custody. We've already told you that, that's already been done. What we'd like to do on physical custody, because we believe this is more than reasonable, would be, currently, Ms. Hurd has 4-hour blocks on Wednesday and Thursday, right? Wednesday from 4 to 8, Thursday from 4 to 8. What we'd like to do to incorporate her back into Aslan's day-to-day routine, right, which is Wednesday, she could take Aslan up from school, have her after school into the evening overnight. Thursday morning, she would take the child to school, she would get that experience. Child concludes the school day, she would pick Aslan up, and she would have an after-school evening routine with Aslan until Thursday at 8 p.m. So it's basically overnight, Wednesday to Thursday at 8 p.m. Pick up from school, and then an exchange at Starbucks at 8 p.m. on the back end of that. We would like to do that for a month, okay? At the conclusion of that month, we would keep the Wednesday after school to Thursday at 8 p.m. That same block would remain in place, and then we would add in every other overnight Friday after school to Saturday at 6 p.m. That would proceed for a month.
So I'm sorry, so for the next month, it would be Wednesday from school
to
pick up from
Thursday at
school went to Thursday at
Thursday at
8,
8 p.m.
and after that, it's Wednesday after school to,
Then month 2 would be the same, Wednesday after school to Thursday at 8 p.m. And then every other week, she would have a after-school Friday pickup, overnight Friday night.
it's just like a
to
week
Saturday-
1, week 2 thing,
to
okay?
Saturday at 6 p.m. Well, no, because on that week 2, she'd actually have the Wednesday overnight and the Friday overnight.
Okay, so it would be Wednesday until,
Wednesday after school to Thursday at 8 p.m.
right, on week 1, okay, and then,
on week 1, and then week 2, she'd have Wednesday after school to Thursday at 8 p.m. and Friday after school till Saturday at 6 p.m.
why don't we just say Saturday at 6 p.m.? What, she'd be keeping overnight Thursday and delivering Friday morning to school, right?
No.
I mean, he's not gonna come back in Thursday or Friday and,
No, and then then I have a third tier, Judge.
okay, well, I don't get it, I don't get week, okay, so for a month, it's, Wednesday from school to Thursday, 8 p.m. After that, on week 1, it's gonna remain the same if things go well, but on week 2, it would be Wednesday after school. But instead of just saying all the way through Friday night or Saturday morning, you mentioned about Thursday, 8 p.m., and then adding on Friday or Saturday, which means he retakes some custody during that Thursday, Friday period?
You'd have Thursday night overnight, and take the check, because it's alternating, judges, because it's not everyone. And then what we would do is on the 3rd, she'd always, again, consistently, the Wednesday overnight to Thursday.
Okay.
And then we'd add in Friday, Saturday, Sunday.
Why don't we make it simple for me? After 1 month, week 1 would still be Wednesday after school to Thursday, 8 p.m., right?
That's what.
Okay, let's make this abundantly simple. On week 2, after 1 month, she would receive this day and this time to this day, this time, and then if there's an interruption in that, and Ashlyn goes back to dad for any period, then it would be, and then this day and this time to this day and this time. Or if there is no interruption in that, then let's just give me the day and time she'd pick up and the day and time she'd
I
return,
understand, Judge.
with the understanding she has
I
to
do.
deliver
You
to,
don't
she has
like-
to deliver to and from school.
Well, then what we could do then, if you don't, then we could just.
It's not a matter I don't like it, I don't understand it. Are you saying
just
that on
keeping-
week 2, he interrupts her time and has some Thursday or Friday time of his own?
It's not that I'm saying he interrupts her time.
A
I
poor
just-
choice of words,
Yeah,
but he would retake,
we were trying to give her, every week, she has one overnight, and then what
Okay.
we were doing is giving her every other weekend and expanding the weekend. Now, if your preference is to not have a break, we could always.
no, I don't, no, it's
Or I'm saying,
more,
if you
it's
think
more
it-
fun,
if
it's
you
more
think it
fundamental,
makes
it's
more
much more
sense.
fundamental than that. I don't understand it. The only way to get me to understand it is you tell, week 2, instead of saying, and then she resumes and gets this extra Friday or Saturday, just saying week 2, she gets this date and time
Okay,
to this date and time.
okay, so well,
And
I'm sorry, but you and I do this sometimes.
if there is an interjection in there where he has some of that, okay, let me ask this, maybe this helps. On week 2, would he be having some of that time? That's, Like on Thursday and Friday.
Week two, he would have all the custodial time with the exception of the overnight Wednesday to Thursday at 8 p.m. and Friday night to Saturday at
this
6
is
p.m.
exactly what I'm asking. Why are we having this to Thursday and then pick back up
Exactly.
Friday? What happens, what's happening on Friday?
What I was going to say, Judge, is what I was trying to say, Your Honor, is that I just was modeling always having a consistent Wednesday, but to address what Your Honor has pointed out as a reasonable
I'm
statement,
not,
which is,
I don't have a problem with the schedule necessarily, I'm just saying I don't get it.
right, so,
What I don't get is, why aren't we just saying Wednesday to Friday night or Saturday
well,
morning?
that's what I was gonna say.
Why are
Judge.
we, what's happening on this Thursday to Friday
It's-
thing? Is Ashlyn going back with him and then back to her?
It's just, Judge, do you want me to answer the question, or do you want
Do
me
you
to?
understand it?
No, honestly, I think I was,
I'm sorry, can I take a recess for a second, Judge, because I'm really having a hard time understanding. You asked me to set forth what I had proposed, that's what I'm trying to do. I understand Your Honor didn't
Okay,
understand it.
let me put it this way,
But-
like, if, it either goes, humor me, either a schedule goes straight through, maybe if we fashion it this way, to this day and time, to this day and time, where there's no interruption with.
I'm just going to say this attorney did this to himself. Why did he have to schedule such a complicated thing in the future? Why couldn't he just make it simple? He did this to himself. And now he's mad.
What I'm trying to say,
Or
Your
we
Honor-
build that into it, and then on this day and time, you
What
get,
I'm trying to say, Your Honor, is exactly that, is that I sense that what Your Honor was pointing out, reasonably so, is why bifurcate it. And what I'm saying is, it's just the way that I crafted it in my head. So we could certainly do week 2, when we expand to 2, is instead of it being the Wednesday to Thursday and then Friday, Saturday, we could just go Thursday to Saturday.
right,
That was what I'm.
okay, good,
Okay,
good.
and then
What
we-
time Thursday?
It would be after school Thursday till Saturday at 6.
6 p, okay,
But but again, every other weekend,
right,
right?
so
So
what's on the table
So then what
then,
we do is we would do a
Perfect.
Thursday, so
Okay.
instead you go Thursday to Friday.
because these orders have to be actually that precise and nitpicking, they really do. So,
Right.
week 1, for the next month, the same schedule, Wednesday from school to Thursday, 8 p.m. meaning, of course, she delivers to and fro school Thursday. Then, after 1 month, a rotating cycle where week 1 remains Wednesday after school to Thursday, 8 p.m., but week 2 is Thursday after school to
That's-
Saturday, 6 p.m. Okay, perfect.
Perfect.
Okay.
And then what we would do is judge exactly the same thing in starting in month 3. We would do the same thing the Wednesday after school to Thursday every time. And then we would just run the next segment longer. So on the week 1 would be Wednesday after school to Thursday at 8 p.m. with exchange at Starbucks. And then the week 2, we would go Thursday after school through Sunday at 10 a.m.
Okay,
And then that
now I
would be
think
the
I
schedule.
get it. You got it? What they're proposing?
That was a good point, Judge. I think we,
No,
I think that's your point about the
I would like to have some consistency, so then.
You're way ahead of me.
Yeah.
You're reacting to something without first telling me. Do you understand because it's worth asking, because I was having a little difficulty. Do you understand exactly what they're proposing? Don't tell me whether you like or dislike it yet. Just tell me if you understand, do you understand the schedule they proposed? Not do you agree with it or like it, do you understand what it was?
I don't know if I do understand.
Okay, good, let's go through it then.
Okay.
Go ahead
So
and pose,
the first
ask them
month-
these questions.
Okay,
Go
so
ahead.
the first, let's start, okay. Month 1 is what, the Wednesdays and Thursdays, but I'm getting an overnight on Wednesday.
So the first tier of it would be month 1, it would be you pick up after school on Wednesday, and you would
So we say
return-
Wednesday from 3,
and then you return Aslan Thursday at 8 p.m.
so Wednesday from 3 to Thursday to 8.
That's correct.
Okay. Month 2, right? And
2, there's a week 1 and week 2. So on week 1 would be the same Wednesday after school to Thursday at 8 p.m. Week
and then
2, we would do Thursday after school until Saturday at 6 p.m.
So Thursday at 3 until
And then
Saturday
after
at 6.
an additional month, okay.
Saturday.
The one constant through all this is week 1, okay.
And then
And then it would go 1, okay. Then month,
in starting month 3, you would have again week 1 consistent Wednesday after school till Thursday at 8 p.m. And then the week 2 schedule would commence Thursday after school, but it would run all the way until Sunday at 10 a.m.
Okay. Now, you also have other options. If you were to agree to something like this, but were to say, I'm not necessarily giving up my right to a trial, there's all sorts of creative things you can do. 90% of the time, if we provide something where we say you don't necessarily give up your right to a trial, but make this work a month or 2 or 3. If it's a disaster, come back
I could,
at that status check and tell us. 90% of the time, someone either says, I can live with this, or can we tweak it a bit? Fewer than 10% of the time do they say, this is unmanageable, I wanna blow it open, I want a trial. So it's things to think about, you have
opposed to that
options.
if I'm not giving up my right to a trial and I would be opposed to like, kind of like putting it on hold and attempting this and see
Right,
where
but
we
it's
go.
everyone has a lot more information, including you. Your information for a joint physical custody situation, which you're interested in,
Right, so-
might make a lot more supportable if we can see how this, something substantive, including overnights like this progresses. So what they're offering, of course, for next 30 days, Wednesday after school to Thursday, 8 p.m. After the first month, week one would still be Wednesday after school to Thursday 8 p.m., and week two would be Thursday after school to Saturday 6. And then after an additional month, week one still remains a constant throughout Wednesday after school to Thursday 8 p. But this week two would now be Thursday after school all the way through to Sunday morning, like 8:10 a.m. So that's where we're at. Maybe it's a really giant step from where you were.
We would agree, Judge. We thought, our estimation is it represented a pretty enormous, compromise, given what.
Is there a way
I'm
to
sorry?
get a few minutes, just so I can like kinda.
If you think it'll
soak
be
this in a little bit,
productive,
and
you
then
guys
I
can.
wouldn't, if I'm not actually,
You mean
give me my
to, you
rights
mean to
to-
negotiate or just think about it, or to continue to chat with them, or to think about it, or both?
well, I know I can't ask him certain questions, cause he represents,
I'm not-
like,
I
can't
don't,
ask
I
him
don't
certain
think,
questions,
I
so
think
I
you're
kinda wanna just get
probably,
some-
if you're off the record and negotiating, I think 98% of what you ask him, he's gonna feel comfortable asking, unless you're penetrating deep into private communications with this client, which I'm sure you're not. I think he'd be comfortable telling you what he thinks about just about anything.
I just like how you mentioned that I'm not waiving my right to a trial, I'm not
It's
waiving my right.
an idea, there's all sorts of ideas. that
But
can-
kind of like postponing this to at least attempt it and try, I would,
I respectfully, and I appreciate the
Again.
sentiment, I appreciate your suggestion, or that, for me, is problematic from a legal perspective, and the
That's-
time that my clients invested. So-
Well, it'll either strengthen her, I agree, it could either strengthen her case from where it would be today, perhaps significantly, or if the things go really well, if things don't go well, then it would strengthen his case, so it's significantly from where it is today. So it's a gamble either way. I think Mr. Freeman's been alluding to this thematically, and
I think Mom is beginning to screw it up right here, right now, right in the middle of court.
as to where he's going philosophically on this, and I feel the same way. We're getting so hung up on these designations rather than saying, let's look at the time, let's look at the week, let's look at the quality of life, let's look at a generous timeshare with due consideration for a child's schedule, his work schedule, your schedule, all these. Let's look at real life, how we can reach something we agree to and not be overly concerned with some label, which is really a malleable label anyway. So I think there's a little too much emphasis on that. Oh, I have to have joint physical custody, rather than let me get a schedule which really provides quality parenting. Translation, you'd much be better off with a more generous schedule and not have the designation joint physical than you would a joint physical schedule where the schedule doesn't really reflect as generous a situation. So let's just focus on getting some real life quality time and not so fixated on these designations, which there are cases where with custody of a 13-year-old child where primary parent changes hands 4 or 5 times until that child is 18 and all that. So let's not get too hung up on that, but I agree we can't ignore it either. But let's focus on what's working. This seems to be a pretty significant, if not even dramatic, expansion from where you were. How realistic it would be for the court that it would equal this or go beyond that, I don't know, because I haven't heard the evidence or arguments, but based on what we do know so far, which isn't everything, because we have to hear updates from the parties and their arguments, I think it's something, I dare say, if you had an attorney, they'd probably really give a lot of, not just consideration to it, but I think they'd be enthusiastic about it. But this is what's difficult, because you don't have an attorney. These are just observations, and you don't know whether to take my word for that or not, so, and I get it. And there's always a possibility you might get an unreasonable attorney who doesn't view it the same way as the court, so I get it, you know. So, I don't know.
Is there a way to put this on pause for today and let me try to get some advice that I could?
Well, we do
like-
know this, and here's another, if you wanna think outside the box a little, maybe it accomplishes everyone's purpose. you're understandably want to get some track record, which is gonna significantly help you. On the other hand, they figure their position is best to strike now in terms of the ultimate designations, and I get that anything else could maybe weaken that potentially. We know certainly you'll have the ability to reflect on this overnight, at the very least, because we can't do a heck of a lot with what we got remaining today. And we're back here tomorrow, so you can certainly sleep on it tonight.
I would appreciate that, if we could do that, maybe.
Sure, I mean, if you want to get started today, that's fine, if you guys want to, for the next half hour, but you can certainly come in tomorrow and say, hey, I want to chat with Mr. Friedman and his client again, and the marshal will tell me not to come down right at 1:30, but to hold on until you guys send for me.
Okay.
Huh?
I could agree to that.
Okay.
If that's
Now,
reasonable, then
with
I'm
that
not.
being said, you guys have probably gone 12 rounds already, so you may not necessarily be interested in utilizing this last half hour. But on the other hand, if you really do think we'd at least get opening statements or a witness start some testimony, that's fine too. Then tomorrow afternoon, she's gonna let you know whether, hey, let's try this for a while, or,
So Judge, I'm happy.
and I understand the concern, I do.
I'm happy to break for today and give her some time, but I just wanted to be clear about what the offer is and what we're willing to do, and then what we wouldn't be, which is,
Right,
I'm absolutely happy to codify this stipulation, resolving the remand. It would be a final order, this would be the timeshare, the joint legal language, we could certainly spend some time fine tuning a holiday schedule, what have you, okay? But it would end there, and then from that point forward, to the extent that Ms. Hurd believed strongly that a custodial modification was necessary, she thought she needed primary, or she thought she needed joint, what have you, then her legal recourse would be to file a motion to do that.
Here's the one problem, it's a little hard to explain, but, see, if I was in this situation, I'd do exactly that as any
Right, 'cause then that
good
puts me
attorney,
in a
where
different
because they wouldn't
criteria.
say, after 90 days, it automatically expands to this, because then they'll say, gee, but it hasn't been progressing in an acceptable manner, and then if the other side argues it is, then we're getting into largely a subjective argument about how the visits have proceeded, but it puts them sort of behind the 8 ball, where it's presumed that if they've proceeded adequately, as opposed to, maybe they expect this to proceed very well, or in a sterling matter, and maybe just not an adequate matter. So it puts them in a defensive posture whereby they have to be,
Often I think that. Often the clock hits 4:30 and I'm like, oh man, I should be asleep right now. What am I doing? But then I try to sleep and I can't, so it doesn't matter.
getting sucked into an argument subjectively as to the quality of the visits and how things have been progressed. And there's sort of a built-in presumption then that the burden of proof somehow is shifted to them improperly to defend themselves against losing primary physical custody. So they really can't be in that position, but you can accomplish, I think, the same purpose, protecting you fully, while also protecting them, which would, and requiring that it's just not gonna be enough to show that the visits have proceeded adequately. We still may need a bit more than that before agreeing that a joint physical custody is in place. And there may be other things. Let's say it proceeds adequately, but let's say we're still having problems with debating these developmental milestones, which, as you can tell, the court has not much tolerance to, because, to be blunt and a bit unkind, if you guys are in dispute on that, it doesn't really matter what your guys' opinions are, except to the extent an expert or therapist have said, there are pretty wide open options here, and opinions and input and of parents how to proceed, they can often decide these things. They'll seldom say that. They'll say your input and your questions are important, but your decision as to how to proceed is in the hand of the experts to a large extent. So there may be more involved. There's that. Let's say the visits go without too much of a hitch, but we have communication issues that persist. disagreements as to medical developmental issues. So they don't want to put themselves in a position where all these other matters could be quite problematic, and yet the visits proceed, let's say, in a C minus or adequate or passing fashion, but all these other issues are not proceeding well, that they would lock it in where that he automatically loses his primary status. So we have to do something which is fair and reasonably protects both sides, and I'm just throwing out some ideas that might work, and you'll have the night to think on it. No.
If I could have the night, I
Sure.
would appreciate that.
Well,
Like,
we
it's-
will be
it's
back
kind of
tomorrow
a
anyway.
lot.
You can absolutely have the night. The only reason that I said what I said is because when we wrote before and then we came back, I just want to be clear on what the offer is that we're willing to do and what we're not. And so if you understood me
Now I
and
get
you're
it,
clear.
now I get it, yes, right. I didn't,
It's not me sandbagging, I'm not looking to take something
No.
from you, it's just simply
I
based
think
on.
I understand if I could just.
And I don't get, and I
Process this
can't
a
get
little
it too
bit.
much into, and I usually, when people are unrepresented, it's a little tenuous to get into too much, oh, if you're a lawyer, you should definitely accept this or that, or you should definitely reject this or that. But I think it's on safe grounds to say that if you had a lawyer, I think your lawyer would give probably serious consideration to this, probably even be pleasantly surprised by it. That could be wrong, but according to who you hire, but I think the vast majority of them, the experienced ones would probably think that, but there's a bit of speculation there, but I guess the point I'm trying to make, it's a pretty significant leap from where we were. It's an unusually large leap, not that all such, not the cases similar to this are against the backdrop of an identical fact pattern. All cases differ, but cases can still be lumped into certain general categories. And most cases in your category with this degree of contact, it generally would be relatively uncommon for it to proceed to this level. If that's a translation that sometimes offers, accepting an offer is better than you wind up with a trial, sometimes that's the case. And it's a little hard to know for sure until we hear the evidence and arguments, but I'm trying to tell you that it looks like a pretty generous leap, but, and I understand your concern about, you want to get to joint physical custody, that's your goal eventually. And their concern is, yeah, but we're not going to just automatically indicate that if this schedule is complied with for a short amount of time, that automatically occurs, because there's a lot of other considerations. Plus, he unduly jeopardizes a hard-fought-for legal custodial status that he'd lose all force and effect of in terms of burden of proof, et cetera. So, I don't know, just
That's very, very accurate.
So I understand where both of you sides are at. So
Thank you, Judge, for
Okay.
weighing in
Sure.
and helping us. Ms. Hurd, it sounds like you want to take the evening.
Yeah,
so
if you
can
don't
see you tomorrow.
Okay.
Okay.
So we'll be in recess now. If you guys have anything else you want to speak
Judge,
about
we just need your
overall or
personal
something.
cell phone so we can call you this evening if we run into a snafu.
There you go. Very good.
We are on the record.
We'll go back on the record. All right, we just heard the 6222669, same appearances as yesterday. Okay, and appreciate the parties taking some significant time to negotiate yesterday. It didn't necessarily bear fruit, but, well, maybe, who knows, maybe it did to some extent. Is there anything of interest to report?
So they did. They stayed and they tried to negotiate. And it didn't bear fruit. I bet you that whole crazy mixed up plan that we all went through and Kelly wrote down is gone right now. What do you think?
We were sitting down, Judge, Ms. Hurd came in, marched along, asked, I have not spoken with Ms. Hurd, she just said to get you, so.
Okay. All right.
I don't know.
So, based on that, how do we wish to proceed?
I wish to proceed. I would like
Okay. Okay. Back to now, as far as the order of who goes first and all this was originally,
Can I make a formal
I mean,
oral
I don't know.
request?
Pardon?
Can I make a formal oral motion?
Uh-huh.
I would like to ask this court to recuse itself,
Okay.
based on bias and prejudice. I don't think I'm gonna have a fair opportunity to have a fair trial here, because
Why
I'm
didn't you
self-represented.
make this request some time ago?
I was, cause we kind of moved forward in November, and then we took 10 steps back yesterday, and my daughter
You didn't take
is
anything back,
suffering.
there's been no rulings.
Your demeanor, the self-represented litigant, you let
Okay.
him talk for
Okay.
over
You
and over,
spoke- you-
he's allowed to speak,
I'm extremely.
and I'm interrupted
ex-
like I am being right now.
Okay, I'm extremely, because this is, the same with him, this is not conversations in court where you say whatever you want, I need information. Actually, this court bent over backwards and the record speaks for itself. I mean, I really wouldn't care, if this had been a few weeks ago, I could have entertained it, but now we're in the middle of all this.
Your Honor, I would argue that the appropriate forum to have requested a recusal would have been at the time of the appeal. There's a legal mechanism to have done so, Ms. Hurd failed to do so. I would also state for the record,
It's time.
setting aside the personal issues, I have known Your Honor for over a decade in a professional manner, and I have never observed you to be anything but fair and balanced. And I
Well, of
would
course you're
also,
gonna say that.
Okay, well,
and I would
well, yeah,
also
I
note
know,
for the
but, you know.
record, that much to my dismay, I would agree with what you said, that you were overwhelmingly accommodating of Ms. Hurd
And that's
yesterday.
not true, and again, this court constantly listens to Mr.
okay,
Friedman,
okay,
uninterrupted, like
the
you
record,
didn't interrupt
okay.
him right then, but now you're interrupting me, and his word
No,
is taken as
because,
fact.
because I do you a favor when I get you on point to say what should the schedule be rather than all this other stuff.
That's not true.
Okay, okay,
Your Honor, I would
okay.
like to ask you to recuse
It's
yourself. I don't
just-
think I'm gonna be given a fair trial.
it's just
And my
too-
daughter deserves
okay.
a fair opportunity to not be
We're
in
gonna-
diapers and to not
we're-
have rashes
okay,
for 2.5 years.
to do you a favor, for someone to judge the issue of bias, they're gonna judge that largely based on the eventual rulings. I'm gonna give you an opportunity to obtain some eventual rulings, which should on their
Can I
face
make one
speak to
statement
bias
then?
or not.
Your findings from last August, I wasn't gonna be given a fair trial then. Your findings that found me, there's not one documented in the evidence
Okay.
medical record, not a single one from my daughter, not a single one.
You know.
Except there was, Marshall, this one.
Thank you. You made your motion.
No,
I-
this is what I was found
I would have
medically
been,
negligent
thank
as.
you. I would have been very open to this
Okay,
a
this
couple
is
weeks
admitted
ago.
into evidence, and you
That's
can't
fine.
even read her name. You
That's
can't even
fine.
read my name.
That's fine.
And this is what the court found me to be medically
you.
negligent on,
We're
based
gonna,
on this.
we're gonna start, and we're gonna push it through the rulings, which give you 10,000 times more ability to complain if we actually have rulings, rather than, well, he did this or he said that. You're gonna have actual rulings on the record, which are gonna guide you as to this.
Then can
Well-
I ask the court, look at the evidence
Yes,
and not
yes.
listen to the lies of
Let's,
Mr. Friedman?
okay, you two are gonna have the obligation to show me where the other side is not telling it like it is. The court will decide what's a lie and what's not. Let's get started on what's really important here. Your
Okay.
daughter, this thing's gonna go on and on. This would have been tempting a few weeks ago if I thought someone could get on it like right away. But if the court stopped midstream now, it'll be 4-6 months.
And my daughter has IEP.
And what happens if it takes
This judge wants to. He's like, I'm in. I recuse myself. Bye, guys.
takes
She
4 or
needs
6,
help now.
what
She needs
happens
help
if
now.
it takes 4 to 6 months for someone else to hear this?
Your Honor.
What happens to you in
I
the
just want-
interim?
She's been 3 years now. I've been bringing this to your
So
attention
you
since
want a
November. Can I finish?
you
You
want
asked me a
okay,
question. Can I
see,
finish?
yeah, my question, you want a procedure that's gonna delay this even more months?
But I feel like this is gonna delay. If you don't
It's
listen
not.
to me honestly, and if you don't look at the evidence
The,
honestly,
we, the,
I'm gonna have to
every,
go to appeal
okay,
again, and this
that, I
is
don't care,
gonna
okay,
delay.
you have a right to do whatever you want. Everything the court did was geared to facilitating a possible settlement. That's everything.
Right.
And that's what it was, if you
And
wanna
the
point to
settlement was
if you wanna
being
point
fair
to
for me to
bias,
never
and
get
if you
joint
wanna point to
custody.
bias in the record, the bias has to be during the contested custody proceedings, which is where we're at now, and everyone's gonna get to present their evidence, and we're gonna start,
Your
Okay.
Honor,
okay?
I would say this, I will absolutely defer to Your Honor, but given the
And if you
remarks-
join her in this request,
given-
that's fine, I don't care.
Given the remarks made by Ms. Hurd
Mm-hmm.
just now, my sincere concern, Your Honor, while I do not think it will in any way be outcome determinative, whether it is you or any of the other eminently qualified judges who sit where you sit, okay? The fact of the matter is, it's very clear to me that whatever Your Honor does from this point forward, Ms. Hurd has deemed that if it is not exactly what she wants,
I've never said
she's
that. Please
going.
don't put words in my mouth.
I'm not saying she said that, that's
Yeah.
what's clear to me. So Judge, while I am
It's making a
tempted to say
presumption.
if that is what she wants,
My
That's not what I
greater concern is,
I'm tired of everyone assuming what
you
I'm
know,
thinking.
my
when I
greater
want to say,
concern is
like,
where I think this thing is meandering. My aggravation is I'm not taking it personal. If I took it personal, I would say it's gonna be different with someone else. I have a feeling that that if someone doesn't rule exactly half and half, you're gonna keep doing this to every single person, cause
You
you've
have
your
a right
mind
to
made.
feel that way, but I would disagree.
Cause you've
Your
let
Honor.
me know, you said it many
No,
times,
I-
that's what you
I
said.
just want what's fair and for the evidence to be looked at. When I'm deemed
Okay.
medically negligent based on a
Okay.
piece of paper that doesn't even say my daughter's name and doesn't say my name,
That's
I'm
fine.
I'm
If
like,
there's,
and that's what
well,
he's
we're doing a
referring to.
do-over. If there's gonna be any medical negligent findings, those will be found. Now, if you both agree to this, I
I
mean,
think you understand what I'm saying, Judge, which is
Uh-huh.
simply that when this specter has been raised, as ill-conceived as I believe it to be,
And I apologize for that, on the record. I apologize for my not following the proper protocol. Sorry, I'm not an
well,
attorney.
the point
Whatever Ms.
is
Hurd
you're
says,
you're
you
getting
never should.
so sucked into this protocol and everything, you don't stop to think what's accomplished by a delay. Let's say you got someone who you perceived as more predisposed.
I'm sorry,
toward you.
John.
How many months before you get to him or her
I
for
don't
a
want
trial?
someone that's
4,
predisposed
6?
towards me. I want someone that's predisposed
How
towards
many,
her.
okay.
Not me,
Okay,
not
okay.
Mr. Prepared, her. I want someone
Okay,
that's solely focused on her.
am I failing to communicate? It would be 6 or 8 months before someone could
And if we
probably.
proceeded now and things
Okay.
didn't go correctly, and then would be another year in appeal,
Okay.
like
What happens to you and your visitation rights if it takes 6 months to get to trial before another judge? In most departments, ordinary course, 8 months. What happens to you in the interim?
there's temporary orders that
Well,
can
there
be
could
set.
be,
And
there
based
could
on
be.
motions and the evidence that I have, I would,
There,
I would
there,
hope that
there,
they'd be fair
there
enough, and I,
could,
at very
there,
minimum, would be
there
joint custody
could be,
beginning today.
but no judge, until they make findings on the record on a case like this in remand, can change the custody configuration pending trial. They are prevented from taking primary custody
I've
from one
followed Roe
person.
versus Roe, and
Get-
they've done the
okay,
exact
no,
opposite.
no. With full acknowledgement of Roe versus Roe. If someone is gonna take primary custody from another, and maybe whether they should or not, maybe they should, or dissolve primary custody and be awarded joint physical custody, it
Never-
must happen after a trial. And you research this so you know this. It must happen after a trial, you know, so.
She never should have been taken away from me and given sole
Okay.
custody to him. That's where I feel
You're,
the ruling
if you
is
read,
saying.
if
It
you
goes
read,
back to
if you
joint
read the
custody.
decision in the decision that you fought so hard for, it doesn't say it's reversed and you get whatever you want.
No, it
It's
doesn't.
basically a do-over for more findings. It's a
Right.
do-over. So take this opportunity.
Judge,
Guys,
as
you
I
know?
said, if I can.
So,
if I can
okay,
just get that
so
out
the
for
court,
record.
apparently, the court's getting pillared for trying to see, understanding that parties are much more likely to get along for the sake of their child if they reach an agreement that they arrive at, instead of having one shoved down their throat by someone who doesn't know their child.
And
which
Judge,
is-
this is unfortunate, and if I can just, Ms. Hurd, respectfully, if I could just get this statement out without being interrupted. It is not because, in my estimation, Judge, I believe that you have any bias in this case, but what Ms. Hurd has made abundantly clear to the court just now is that, in my opinion, is that if and when, in my opinion, she does not get the order that she wants, she intends to appeal, period, and now she intends to have used the entire day wasted yesterday to try and accommodate a reasonable settlement as another basis. And since I'm already, it appears, my poor client who has been shouldering the financial burden, not only caring for this child with a $0 in contribution from Ms. Hurd the entire time, and all of these fees, is then going to be faced with the prospects of yet another appeal, and then potentially another
Okay,
proceeding. So
but
Judge,
that's exploiting the fact that if this was frozen in time for many months, all she would be able to accomplish is some limited temporary progress pending a trial, but no substantive progress can be realized until following a trial or a stipulation and agreement between the parties. And I don't know what went so wrong. They would look like there was,
I don't either,
progress
Judge.
I'm willing to settle for reasonable custody. I'm not going to.
why don't we do
I'm
this?
not gonna waive the
Let
rights
the
of my
court,
daughter.
the
She
court,
deserves-
okay,
she has a
the
right not to
court,
be indicted.
okay.
She has a right
We're
not to be
here,
in
we're here to
rashes.
hear witnesses under oath. Yesterday, I regret that
I have a witness that could testify to
thank you.
this.
I regret that I took the high road yesterday and I wanted to give these parties an opportunity. I regret that. If these parties are committed to tearing each other apart under the guise of, oh, I just want my day in court, they can both have that.
Your Honor, you continue to say these parties.
Well, they did, failure to reach a settlement is a two-way street, so, I don't know.
Okay, Your Honor, I think that's one way.
I mean, I understand, the offer that was extended, and I understand that it was built in progression, and at the end of it had a reasonably generous result, at least pending final resolution, and I get that, and
But then I'm waiving my right to a trial, that makes the burden
Okay, that's fine.
completely different for.
And that's why
change
you
of custody,
exercise,
and
that's
where
what,
I
and
have
that
a
was your,
problem.
that was your choice, to not agree or have a trial, but not at the last minute,
Because
you know.
I had
And
to see conflict.
candidly, if I gave you your way, I think I'd permanently poison the record where they say, this young woman is saying everything's unfair before evidence was heard, and I am very confident, and it's all on the record, as you say, we're on the record, I'm extreme, you could nitpick things out that you don't like, but I'm very confident that in general, painting with broad strokes, everyone would agree, this court was trying to facilitate something sensible to reduce or eliminate the conflict and go from there, so I'm gonna hear a couple of witnesses. If it dissolves into some sort of circus or something, I may be tempted to accept her suggestion or something. But we've waited all these months to start hearing the evidence, so I need to start hearing it.
Yeah, about 6 weeks since it was set, but.
Well,
but
it's been a long time.
My perspective would be, Judge, by all means, like I said, want to fully comply with this court. Wanted to make that reservation that I am concerned that anything we do going forward, as much as I agree with the way that Your Honor has handled these proceedings being completely above board, Hurd's already made it very clear what she intends to do with.
Right, but I
anything
think
we do.
I think his motivation is he knows this delay freezes this order in time with very limited contact, and she references, well, there can be temporary orders pending trial. There can be, but it's gonna take a long time before another judge hears it, and then the law of averages, our judge is gonna say, since it's so conflicted and so contested about what this time expansion should look like, whether it's all the way to joint physical or something else, they're gonna package it for trial in all likelihood. I can't guarantee that, but the law of averages would say they're gonna leave this order in place, the existing arrangement in place until trial, probably.
I'm not sure what.
And if they, and if not, then we're gonna go through, it's gonna be the same exercise over and over.
I'm not sure what Your Honor meant by motivation, given that my client came.
I didn't mean there's a diabolical motivation, I mean there's a
Very prepared to resolve.
strategic motivation for him, contrary, me be
Newbie,
blunt.
how are
She
you?
thinks a recusal of judge supports her. It actually supports him because it grinds things to a halt till it's reassigned and until it's transferred to another judge. Absent stipulations, any progress is really, really limited, because a judge who sees that this was on remand is gonna say, I'm not gonna let an ant crawl unless it's with findings and testimony on the record. Chances are, I can't know for sure, I just don't see people being too proactive when the court's saying, everything you do, you expand or remove minutes or hours, you gotta have
Did you get the surgery that goes to the front yet? Did you do that?
findings, you gotta be testimony. I just don't see, I'm being practical.
I understand that you are, Judge. I was
Yeah.
approaching it more from the perspective that the arguments have been made on the record already by Ms. Hurd, and that's my concern, is that it's baked in now. Not that my client is somehow going to benefit from this. Again, reminding the court, what my client's benefit has been is single-handedly caring for a special needs child.
No, it's not.
With absolutely no financial contribution from the other
He
side,
gets
so.
contribution.
Okay, here's the thing, the main problem, the main problem with, thank you, the main problem with pro pers handling their cases, which fortunately is not a problem you share, you handle your case presentation and preparation well, which most pro pers don't. But if pro pers don't get caught up on that, then they get caught up on the second thing, which attorneys very seldom do. It becomes all about the personalities in the courtroom, the lawyers, the judges, and other people, rather than the focus on where it should be, that little girl right there. And it becomes about everything else. And that's the main problem I have with these type of situations. And I wish I always
sorry,
wished,
Your Honor,
I've always
I'm
wished if
representing
someone,
myself.
if someone
I wish
can't
I wasn't.
afford a lawyer, I wish that, like in criminal case, we had a mechanism to
I wish
appoint
so
them one.
too. I would love that, because this is not fun for me at all.
I would state on the record that I have long been a proponent of expanding Gideon to the
Yeah.
context of civil family law cases. We do
I
it
would
in
agree
cases
with that,
of
too.
termination, which involves fundamental rights, I believe the same.
Right,
practice,
and
but unfortunately-
someone's rights to the child is
agree
more
with that.
important than whether they're gonna spend a few weeks in jail, and yet they'll get anytime incarceration's an option in a criminal case, they get a lawyer assigned, so. Gets them veering off a little bit, you're making a point, you know. All right, so, who was gonna go first, and who would sequentially go first after all this?
Judge,
I don't remember.
This is my estimation, and this is what I believe. I believe Ms. Hurd, there are 56 exhibits in evidence. There are findings relative to those evidence. Those findings are not vacated. The court asked for additional findings. They did not strike or vacate the findings. So my position would be Ms. Hurd stands before the court, telling you she has evidence, telling you that she can upend those findings or create such additional findings that she can sway your honor as to a change in custodial designation. I believe, as I said, I think a couple hours into the first day when she took her position, let her go ahead and put her case on.
But we're still with the
disagree.
basic issue, which I think that the court has to take evidence of any developments since that day, even though it's a little dicey. Usually an appeal freezes information as of that date. When it's remanded, it has to be the evidence as of that date. But if if there's been substantive progress or changes since that date, and we're dealing with a child, the court makes findings that on some level, it has to provide a basis to provide an update of information. And that's kind of
Yes,
the
sir.
dicey thing, reading
It sure
it,
is.
so that it's not like a complete do-over.
This case has me sucked right into it. I can't help it. You need popcorn.
I would have preferred, it would have made life easier if they just told me do the whole thing over. That's fine. It would have been a lot simpler. But instead, it's like you said, to read it and reread it. They're saying, like, basically beef up these findings as to
And we did this-
exhibits
we
which
did
were
this conversation
uncontroverted
back
at the
in
time.
November.
So I am gonna provide latitude as to current situations to some extent, or how they differ from the prior one.
By all means.
Well, with that understood though, who would be testifying first for you?
Well, my expert, who I feel is an expert, you did not object to it when I submitted her.
Who is
back
it? Who is the
December
expert?
13th. She works for Clark County School District with the severely handicapped and disabled. She's
Okay,
a
where is
school
she?
nurse. She's right up here.
Oh, I'm sorry, okay, right here, okay.
So
Okay, so would we
I can
back,
give you her
okay, back
CV.
to, hold on, back to yesterday. Would the potty training, or does it embrace more than that?
The body training and her IEPs and her school, and.
Got it. But can she testify, let's say I say, okay, sounds good, I agree with it. There seemed to be a lot of resistance yesterday when I was saying the obvious. Are you saying that he resists this, and can your expert say
Yes.
she interfaced with him, spoke to him,
She
and he
knows of
resisted?
him, there
Pardon?
can't be an interface with him because he's been ignoring me.
Okay.
But she does know him, she
Okay.
does know who he
Okay,
is.
how does she
And
know, okay, I dealt with that yesterday. If you wanna, someone doesn't talk to you, but you wanna put them on notice of an important child care issue, you put them on
I
notice,
did.
you notify them. How is this witness gonna establish, what if he sits there and says, I agree with that, but, here's what we're trying, it's not work. How do we know he can't, I'm just trying to focus this. How do you know he's gonna disagree with what the expert says, or that he's incapable of complying with it?
Because he hasn't for 2 years, he's had custody of her
Okay.
for 2 years, and it's gonna be
Okay.
painfully obvious that he hasn't.
Okay, maybe we can move on from this and have the expert. Is he indicating that, maybe I'm wasting time, maybe he is gonna say, as the offer of proof, is he saying that will not agree that potty training can commence at this time successfully?
Your Honor.
That's not what I heard him say yet, but I could be
It's
wrong.
absolutely not what he said.
What's he saying? Is an
He
offer.
said the potty training is commencing.
Yeah,
that
just
he-
now, it should have been 3 years ago.
Your Honor,
Okay.
again, can I get admonishment about decorum, please, Judge?
I'll ask, no matter how much, no matter how much it aggravates someone, I'm gonna keep asking a question, not that I wanna ask, but that I'm required to ask, unless you agree with her, I'm not required to ask it.
No.
What point is a witness who says, here's what we need to do, unless I can hook that up with his adamant refusal to do it?
I agree, Judge, I'm saying what he told you yesterday is they are doing potty
Uh-huh.
training. She wears underwear sometimes, and she wears pull-ups sometimes, notably the pull-ups when she's at school. If she's still having accidents in her underwear and accidents in her pull-ups, then obviously it would be nonsensical, which is what he told you yesterday, to strictly put her in underwear and have her at school having accidents. So they're working with her.
I am, in fact, a potty
Second
expert.
answer is, I'll leave it to you through your cross-examination to hook up whether the expert has any reason to believe or not.
Your Honor,
That he's going- that
with
he's-
respect to the notion that this individual who
No.
in a disclosure was designated as an expert. But NRCP 16.2 subsection 3, talking about disclosure of expert witnesses,
Oh, I have that.
there's no expert report.
There
I know.
doesn't need
I
to
have-
be a full
There
report.
absolutely needs to be a full report.
Okay.
The court's gonna let the witness testify,
Except
but
this-
you're gonna,
and I'd
I'm
like
gonna
to
give
read
you an
this.
opportunity to put all your concerns on the record. Go ahead.
Your Honor, I'd like to read this into the record. It's at subsection 3, disclosure of expert witnesses and testimony. Okay, and this is in, Your Honor, 16.205 subsection 3. A party, except as otherwise stipulated, there was no stipulation, or directed by the court, which never occurred, a person who retains
Possibly.
specifically employed
Possibly.
witness to provide expert testimony in the case, or whose duties as an employee of that party regularly involve giving expert testimony, must deliver to the opposing party a written report prepared and signed by the witness within 60 days of the close of discovery. That did not occur, Judge. So if this individual intends to testify as a percipient witness, I would be happy to do some voir dire before she does so on her personal relationship with Ms. Hurd. But if she's intending to testify as an expert, the rule expressly prohibits her from doing so.
I disagree, because she wasn't employed. She's not employed, and I have a rule serious, unless otherwise stipulated or blah, blah, blah. The subject matter on which the witness is
Court's
expected
gonna
to
allow her to
present
testify.
Blah, blah, blah.
But we're noting that we don't have a report, that objection's preserved for the record, and that some voir dire or some initial inquiry will determine whether this is an expert witness or just a personal
presented
knowledge
proceeding
witness,
is
if she has
disclosure.
personal knowledge, so you can call her forward. I think it may be much ado about very little.
I agree.
Because I don't think any of it matters. You guys can do this till the cows come home and act like it doesn't matter. You have to hook it up with, he violently agrees with what he's saying, and she can testify, I've dealt with him and he refuses. You can't just say, oh, no one can talk to him because she didn't talk to him. I suppose that could work if he's gonna get on the stand and make the expert's testimony relevant by saying, I heard that expert and I disagree and here's what I suppose that, let's just, okay, it's gonna take less time to just get this, the court's understanding the built-in defects here, but also understanding that, that remand, I believe, philosophically, unless something's really clear to the court, which you're arguing it is or should be, is gonna err on the side of caution and allowing the unrepresented person to have this degree of latitude. But it's gonna have to be, we're gonna have to see to what extent it needs to be controlled. So let's come forward, please, and we'll go from
Your Honor,
there.
I don't think-
You
Your Honor,
made
first-
it all.
Your Honor, first and foremost,
Yvonne.
may I please, much long, one moment, just to be clear, I note that there is the, forgive me, I forget your name, but she was here yesterday assisting, and I understand she's not a witness. I do see that there's another party in the room, I'm not certain if this.
That's
this
the
is-
witness.
Here might be a witness.
Well, if she's a witness, then Judge, she should never have been in here this entire time.
With that defect being noted, I didn't note it till now, and when I asked, when she said she's right behind me, so, was she here yesterday?
She was in the hallway yesterday,
but
she
she
was
wasn't.
not in the courtroom.
Please come forward.
Well, that's not the,
I'm
Oh,
just
it's
trying
not
to
it?
ascertain who this
that's,
is.
that's her mom.
Yeah.
Oh.
That's not the witness.
On the ground.
But my question is simply, is this a witness, Judge?
I don't know.
Potentially, not right now.
Okay.
Yes,
If she
per
wants to
se.
Remain, let her remain.
And
We'll
she's
worry
not going
about
to
if she's a
testify
witness
or not.
later. We'll worry about that later. If she's, then you got a built-in, issue, if she's been here the whole time. Where's the behavioralist?
Yvonne.
Where is she?
She's out here, Judge. Did you want me to call her in?
Yes, please. The problem with this, the worse this thing gets, that's not a temptation to pass it on to someone else. That's more of a situation where I would dread having someone else to start from the beginning that's gonna do real damage to this family. I think we gotta claw through this one way or the other. Then you'll have a record you can challenge or do whatever you want with your other series of rulings, and that'll be much more that you can grasp onto. What's going. Very good.
Please, thank you so much for coming.
Okay, please
We're
raise
gonna
your hand to be
have you
sworn.
step up here, there's a little step right here, so. Okay, and just raise your right hand, the court clerk is gonna swear you in, okay?
You do solemnly affirm that the testimony you're about to give in this action shall be the truth, the whole truth, and nothing but the truth under penalty of perjury.
I swear.
Thank you so much.
Let
Please
me
be
see.
seated.
Now, Ms. Hurdlin's gonna be examining you soon, and
I
Mr.
just wanted
Freeman,
to do
and
a
they
little-
have some initial, Mr. Freeman has some initial questions to establish background, et cetera, before Ms. Hurd starts on the questions concerning
That's
the little girl involved in it.
That's correct.
Okay, go ahead.
Would you prefer, is it Chavez?
Shaves.
Shaves. Do you prefer shaves or Yvonne? I'm happy.
Yvonne is fine.
Okay. Yvonne, just a few questions. Appreciate you being here. I understand that you were called here to testify. This is
Me
simply,
too.
Anything I ask you is just me doing my job. It's nothing personal to you. Certainly, nobody likes to be in the position that you're in. I wouldn't want to be there if I was you. I just
Well,
want-
you're scaring me now because you just said that.
No, this is deciding good. So, you're here, and the representation is that you're here to testify as an expert on behalf of Ms. Hurd. Do you understand that?
Yes.
Okay. And, how long have you known Ms. Hurd?
I've known Miss Hurd probably since my son went to high school, so that's well over 10 years ago when he was a freshman.
So you've known her for 10 years since your son went to high school, and in fact, did your son go to high school with her child as well?
Yes.
Okay. So is it fair to say you have a personal relationship with Ms. Hurd?
Yes.
Okay. And, when Ms. Hurd reached out to you, sort of as an expert in this case, did you furnish upon her an expert retention agreement that she
No.
had to sign? No.
No.
Okay. And did she provide you any sort of compensation for your expert
No.
services? Okay. And did she provide you with a comprehensive set of medical records for your review in this case?
She had a few, yes. I did review some.
Review. A comprehensive set of records was my question.
Only the ones that recently came in, like there's binders that came to her, and those were like a couple of days before this all occurred. So I think
You
those
got-
came on Friday, and I briefly looked through some of those,
So
yes.
you briefly
Yes.
examined some of the records?
There's,
Okay.
we're talking binders, like, that's a lot.
We're talking about a slew of medical records.
Yes,
that we
slew.
provided to her, yes, we provided those to her. And,
Look, I'm an expert, but no one said I had to be an expert on reading. There were so many words. No, put it in a video. Put it on YouTube.
how many occasions did you have during the scope of your expert analysis to meet with Aslan?
3 times.
Okay, and when were those visits?
I don't recall the dates.
You're not sure
exactly.
when you met?
No, I met with her, I believe we had some dinner at my house probably the week before the trial.
So as part of your expert analysis, you had a dinner with Ms. Hurd and Aslan?
Yes,
Okay, and how many occasions did you have to speak with any of Aslan's medical providers?
I have not spoken to any of the providers.
You've not spoken with her occupational therapist?
No,
You've not spoken with her speech therapist?
no,
You've not spoken with her endocrinologist?
no,
You've not spoken with her primary care physician?
no.
Okay. And how many occasions did you have to, in the scope of your expert inquiry, not in the 10-year personal relationship that you have with Ms. Hurd, but in the scope of your expert inquiry, how many occasions did you have to interview or discuss the matter with my client?
None.
None, so you've
I
not
don't have a
spoken.
personal relationship with your client.
You
I
just
know
have one
of
with-
him,
You just
yes.
have one with Ms. Hurd. And currently, Ms. Chavez, I understand you're here as an expert. Is it not the case that you're a school nurse with the Clark County School District?
I am a school nurse with
Okay.
Clark County School
So that's
District,
correct.
currently part-time. I'm a retired school nurse, so I'm in critical labor and I was a previous school nurse administrator for 7 years.
Okay, so currently a part-time school nurse.
Yes, at a special school.
And how many times have you offered testimony in a civil proceeding as an expert?
0.
Okay, so you've never been credentialed as a.
No, I don't have the credentials for that.
You don't have the credentials.
For
to
an expert witness, and I know the process of it, yes.
Okay. Your Honor, based upon the foregoing, I would move to disqualify her. She just candidly admitted that she's not qualified as an expert witness.
The court's gonna rule on that and any weight the testimony has after defendant has an opportunity to examine her. And chances are whether this is accepted, whether she's accepted as an expert or whether her observations are probative will be determined in the findings of the case. I think that's the most clear, least contentious path to establish it. But I will indicate for the record some obvious problems. She's never testified as an expert, doesn't seem to even be offering herself as an expert, although that Ms. Hurd is offering her as an expert. The witness herself is making no such representations, and she never spoke to Dad, never spoke to any providers, never examined any records, spoke to Aslan
She has spoken to Aslan.
well, she said 3 times, and there's no report issued.
And that's recent.
And also, independent experts, there cannot be a history of them extensively knowing one of the parties on an elongated personal basis. So there's a lot of problems here, but I think because of the highly unique situation of the case, the court's gonna allow Ms. Hurd to ask her
She's actually going to teach Aslan POP.
questions, and the court, which is not the usual approach, is gonna rule on the admissibility of the testimony as an expert at the conclusion of this matter, and if not an expert, then whether as a recipient or fact witness, there's any value to this matter. But yeah, not credentialed as an expert, she's not claiming she's an expert, never testified as an expert, never spoke to one of the parties, met Aslan just 3 times, interfaced with no specialists, did not discuss any matters with the file, with any specialist, didn't review any records. Now,
She did review.
okay, now you're, well, the ones that, but yes, the ones that just came in on the late day though.
And
What's confused, you're saying you're a school nurse, contrary to what Ms. Hurd's asserting, are you representing yourself as an expert on developmental milestones of Down syndrome children?
I mean, as a nurse, as an educator, as a nurse, I can speak to that. I work with special needs children every day. I work in a special school. I've done early childhood assessments, which is a comprehensive development assessment for 30 years. Those are within my wheelhouse as a school nurse. A lot of people assume that a school nurse is there for Band-Aids and boo-boos and things like that, but our role is far more comprehensive in terms of development.
The court's gonna allow, which is unusual, usually these things are nipped in the bud here, is gonna allow the testimony and rule at the closing in its findings whether this witness is certified as an expert, and if not, why not? And if not, does she have any value as a recipient witness as to findings? And candidly, which there was a lot of resistance to yesterday.
Kelly, you're an expert.
The court is having great difficulty determining how any of this, whether she was certified as an expert or not, is gonna make any difference as to what the final custodial or timeshare configuration looks like. Because I already told them we're not gonna get into a battle about who's right or who's wrong about developmental milestones. They are required to meet with the same specialists and follow those marching orders. And if those specialists say, Dad, you need to up the ante, you need to progress, here's some ways you need to do that, there's the way it'll be handled. With all those qualifiers on the record, you can commence with your testimony. Go ahead.
I would just like to state, to start off, that back in November, that's what you asked for specifically, and I
Okay.
relayed that to Ms. Chaves. I showed her the hearing,
No,
asking,
she's
can I
Go ahead.
speak without interruption?
That's
I-
an evidentiary objection, she's
It's okay.
testifying.
I'm just stating for the record that the court asked if I had somebody that could testify to the fact that she was developmentally ready to potty train, and if she should or should not be
Okay.
in diapers at this point.
Okay, but you can't ignore the fact that you need to establish that that's the state of affairs that the court finds should occur, and that he's resisting it unreasonable. Maybe you'll be able to accomplish that. Go ahead.
All right,
Or through your own testimony, or through this, or both. Go ahead.
Can you give a little bit more about your history and your involvement with myself and with Aslan, as well as what you do on a day-to-day basis and how extensive that is?
Okay, so as I said earlier when asked, I have a personal relationship that started with our sons when they were through their developmental phase of high school. So from that, I've had a personal relationship with Kimberly, and as far as my history, I am a school nurse, and I have been that for 30 years, and I was administrator over school nurses. And so in terms of what my role is, by state law and by federal law, we are involved in the educational process of students for access, and we determine eligibility for special education. And to do that, we use developmental assessments, physical assessments. So I do hands-on assessments for kids to determine eligibility from early childhood all the way up to high school. And currently right now I'm in a special school that's 90% autism and intellectually delayed. And so I have students anywhere from K to ungraded in a special lockdown facility due to the severe disabilities that they have. So that's where I am currently, although I retired and came back during
And
COVID.
like you said, that you've
So,
met with Aslan 3 times.
I have
You
met with
actually
Aslan
met with her
recently
3 times.
3 times. I do know Aslan from age 3 when they came to Colorado for a visit of 6 weeks. And I know Aslan from age 4, who they also came back to Colorado for a visit of approximately the same amount of time. I also know Aslan further on in her year of age 4 when Kimberly and Aslan came to stay at my house in Henderson. So I saw some of Aslan's growth and development, even though recently, due to the issues at hand, I have seen Aslan development grow as I've watched her from age 3 at the pivotal times that I've seen her.
And in your assessment,
Yaha.
Aslan's readiness to be potty trained, and evidently you just have said that you worked extensively with developmental children. Did your opinion of when Aslan was ready to be potty trained and when she should have been potty trained, and if in fact your assessment and your opinion on the diapering and the toileting going on currently?
Objection, Your Honor, it's completely compound.
All
It
right,
is,
well,
but
do
if
you
she,
want time?
do you need that broken down, or are you able to react to it?
You mean for me to speak to that?
Would you prefer if it's broken down a couple, 3 different questions?
No,
or do
I
you feel
don't,
comfortable?
I can answer the
Oh,
question.
go ahead.
So, I think the question is whether I'm an expert or whether I'm a personal, I think the hang up there. But regardless, I am who I am. I don't really separate nursing from who I am as a person. So I can answer as knowledge and experience in regards to potty training. Was Aslan showing the readiness skills at age 3 when I saw her for a period of time in Colorado? Yes. Was she also showing readiness signs at age 4 when she was much more involved in the readiness signs, where she was sitting on the toilet, she was actually being successful at various times, and she was maintaining dry for a period of times? All of those were occurring when I observed Aslan with Kimberly when she was in my household.
Right.
So yes,
Okay.
those readiness skills are there.
In your opinion, when should she could have very well been potty trained by and been out of diapers?
Based on what my knowledge as a mother and somebody who's aware of developmental skills and intellectual abilities, I believe that Aslan, it takes about 2 to 3 years to be successful, and it's a constant battle with disabled individuals. But I think I was surprised when she wasn't potty trained currently at this point. That was my surprise. I thought, the average range to train some of these
So you
kids
saw
with,
Aslan being very much ready by the age of 5 and being very capable of being potty trained by the age of 5.
Objection leading.
okay, so where do I go from there?
Judge,
Just-
respectfully, I understand that the court's not
okay.
inclined to have you make an introduction.
Try not to
but this is
suggest the
so-
answers,
the
try not to
entirety of what-
suggest the
can I
answers
just
to
make a
things.
statement for the record, Judge, the
I'm sorry,
entirety-
could you review, what month and year to what month and year were you in the same,
So,
access again to them?
so I observed Aslan at age 3 when she was in Colorado for a good 6.
Hold on, Your
Okay.
Honor. Mr. Friedman's just said to me, whisper, I'm losing bad.
What?
You-
You just winked at me, I said you're being whack, look like,
Really?
Could you not make,
yes, you did, you did,
Your Honor, this
you
is,
did,
Can I-
you did.
What happened?
I don't even know, I don't
What
even
happened?
know. I don't even know, I don't even know,
What did he do?
I didn't. Can we just continue with this? Whatever this is, Your
Do you
Honor?
want to continue, or is this something we need to address? Everyone needs to treat each other with
With
respect and
respect.
dignity, and
And
the
he'll come to my
marshal's
case.
gonna be,
Closely, Judge.
Marshall will be keeping a real close eye on it, he's a hawk when it comes to that. All
you're
right.
over here making noises, making faces, making gestures.
Him or is,
You're distract-
who,
yeah,
him or
him
the
personally.
client?
Mr.
Your Honor,
Friedman,
can I speak? No,
On this issue, or were you, and you mean the question?
no, just the question,
Oh,
yeah.
sure, yeah.
I mean,
In fact, I invite that, yeah.
Yeah, we're taking notes, my paralegal's taking notes, I'm conferring with her, I'm not trying to make.
Okay.
okay, all right.
thank you.
So the period of time that Aslan spent under my household with Kimberly at age 3 in Colorado, she had made some really significant gross motor gains and some developmental gains that I was able to witness. She had some language and understanding due to the signing that she was able to do, and she was beginning to use her words. Her gross motor skills developed significantly in Colorado due to the fact that, she was able to be outside, not in the heat. She was walking on gravel. She was out in the mountains. So she had a lot of activity that prepared her, in my opinion, for the readiness skills of the gross motor needed to do pottying. Plus, she is beginning to develop that interest. Now, because of my experience and my education and my knowledge as a person, not as an expert witness, I do attribute that she was on the way to developing the readiness, or it was ready, but to pursue potty training more successfully as she moved forward in life.
That was 4 years ago, right, to do that.
Yeah.
Judge, Judge, now he's throwing spitballs at me, Judge. Judge, will you please tell him to stop?
Do you know much about the last 4 years?
I know that there has been, obviously, Aslan's been not under Kimberly's care, and there's been a disruption in the consistency that has been provided between the parents for her.
Do you know about how Dad is handling this?
I have reviewed some medical records that I think they.
The lawyer said she winked at him, and then he responded with something, grow up or whatever. So that's what happened. He looked over, she winked at him, and then the lawyer replied to that, and then everybody went crazy.
That have inputs from parents that he has inputted. I have reviewed some texts that Kimberly had provided me that she was sharing with Aslan's father in regards to toileting and kind of trying to get some feedback from him, which was very limited. What I saw in terms of, at age 4, she was still, even though, he was involved in 3 and 4 when I did observe Aslan, she was really ready at age 4 to take on the next level of a longer dry period, things that you look for in readiness skills. Her language was developing. She was really interested. And most recently, I observed her absolutely at my house refusing to put on a pull-up. And she was more than willing to use the restroom. And I reviewed IEPs. I'm not an expert, so apparently, but I reviewed IEPs, and I looked at the IEPs and the progression, and she has made some developmental progression along the way through the IEPs. It is written in there. The part that was concerning to me is that the advocating for a really comprehensive toileting schedule for her in the school was not written in the IEP. And in order for a child to be completely successful, I mean, it takes the parent and the school working collaboratively together, and it's a level of consistency and intensity to get these kids to be trained. It is super important, because if a child is not trained and they're still diapered, some programs in the community for access she can't attend because she's not trained. I mean, there's critical moments of those that might come up. Self-esteem is disruptive. There's all kinds of reasons why it's important for these kids to be potty trained. But I don't think it's a recent that she's become interested in. I think it's always been there. I think there's just no level of consistency that has occurred, whether it's situational or personal. And again, I'm not an expert in that area, but I do have a lot of experience and knowledge.
Now, that being said, I'm sorry, I want to understand the testimony. With these two IEPs,
I looked at all of them.
So those were more recent, obviously.
Yeah, I looked at the most current one, and what it said.
Well, let's get
okay.
what month and year was each of them, if roughly to the best extent?
What do you mean, the month the IEP was written?
Yeah, how recent was roughly when was number one and roughly was number two?
The current IEP, I don't remember the date, but it's current.
Roughly.
It's like, I think it's due in March.
Of this year?
Yeah, so it's annual.
Linus would also be our foremost potty expert.
Due, I believe.
She
it's
studies
due
it
in
every
March.
day.
Of this year?
Yeah, I think it's due in March.
The two
of this
that you
year.
reviewed, when were those two from?
I reviewed all the ones I had from pre-K all the way through kinder to first grade. And a lot of IEPs are written in terms of, based on the classroom. So you got your pre-K setting, you got your kinder setting, and then now she's in a.
Well, I was getting at is you were
Okay.
discussing the state of affairs when she was
Oh.
3 in Colorado. These
She-
IEPs would have been subsequent to that, but roughly when was
Correct.
each of them?
I don't remember the dates, but they're in there. The dates are,
Was the first one 2 years ago, a year, 6 months?
the
Roughly.
first IEP written was for pre-K. So
Okay,
she would have
pre-K.
been, the first IEP was for pre-K, and that
Couple,
would
3
have,
years ago? Okay.
that would have been when she was 3 years old.
4 years, okay.
Okay,
The
so then the
second one?
second IEP would have been written the following annual year, and she would have still been a pre-K. And I believe that in that IEP, I don't have them in front of me, but they all mention, because they mention toilet training in them, but they don't have a concrete plan.
She's 7.5, she hasn't had another IEP since the two that were pre-K.
Correct. They do them annually, so the IEP is coming up, I think, in March.
What happened to the last 3 that they owe us?
There are IEP, every year she has an
Right.
IEP, so there
So-
should be 5 to review.
Right, but the two you referred to, the two for pre-K, means there's a couple.
Arm
There's
rest.
a couple of,
Don't you have handrails? Don't you need to hold on tight? What do you hold on to? What if you fell off?
them, yeah.
Have you seen those? or-
Uh-huh.
Oh, so there
Yeah,
are
I've reviewed them all,
subsequent ones. Okay.
yeah,
So there's
generally,
several.
yeah.
After the 2 pre-K ones, when did the other couple occur roughly?
Oh, they would, if
First
I'm
grade,
remembering correctly, the annual goes from annual to annual, so it would always remain in March.
Okay.
So 2023 would be the last one, then 2022.
Okay.
Did you, and so there's an upcoming one then?
Yeah, the ones so the multidisciplinary team report, the only one I had access to from what I reviewed was the initial one from early childhood. And in that one, she was 2 years and 10 months old, and that's the initial assessment for eligibility for special education in Clark County School District. So that MDT report I did review, and her eligibility was developmentally delayed, not intellectually delayed. And so because of her great strengths that she demonstrated in that assessment, and it's all written in there, she scored an 88 out of 85 up to 115 in terms of developmental scoring. So she scored in the average range. From my understanding, not as I'm an expert as a psychologist, but So she scored in the average range, so the MDT team made her DD eligibility. Now, the next eligibility report, the next MDT is due before the age of 6. I did not have a copy
Okay.
of that one. And that
I was
one,
not
but the
provided
IEPs represent at that time
My secret camera sees you and your cat.
that she was changed, because by law they have to be changed from a DD eligibility to a regular special ed eligibility under IDEA. So she was changed to intellectually disabled at that from that MDT report, but I don't have a copy of that one
Okay.
to look.
Now, with the understanding that you were not privy to this in the hallway, but I was repeatedly, and you might have seen some of it here, stressing to all the parties, and don't seem to be getting satisfactory feedback on this that I need to know. Would you agree that, if you're correct and this is important, it would likewise have to be established that Dad, whether he is or isn't been compliant with this, because you may know he's been the main placement over there.
Correct, I do know that.
Have you seen any records generated on Dad's watch where he was taking her to the specialist that would indicate to what degree Dad is satisfactory complying with potty training or is not, or were there no
So
records?
the
on that?
records that I reviewed to show the
Okay.
parental input, that usually physicians or practitioners, they ask for, what are your concerns? And they were very generic responses that were in those records that I reviewed. It doesn't say one thing or another, whether he is or he isn't.
Right.
You know, it's not that concrete in terms of the records that I reviewed briefly.
And you would agree, if your main exposure is at age 3 and you had this subsequent record review and some recent visits, you would agree though that if you're correct about this, let's just assume you are, I have to be able to establish whether they're both on the same page and he's complying or not, right?
So, I showed you guys yesterday, I think, or the day before, or sometime this week, a picture of the new kitten that we have. And I named the kitten Judge Fleischer, which was a very, very, very bad idea. And I might not keep it. Because all I do all day is yell, Judge Fleischer, get down. Judge Fleischer, stop. Judge Fleischer, don't eat that. Judge Fleischer, stop. Judge Fleischer, stop. Come here, Judge Fleischer, come here. So I'm rethinking this a little bit. He's still young enough. I can switch it up and go back to Rocky like I thought, but I'm not there yet. I'm still keeping it, but it just feels wrong to be saying those things.
Yes,
They both have to be on the same page,
yes.
whatever the correct situation is. Did you see any material, and you, if I understand your response, you haven't seen any material that would reflect on, now, we may get the answers from his testimony, but did you see any records? And I think you said no, but I want to make sure that reflected on whether Dad is adequately handling this issue, or was it kind of silent on that?
No, I didn't see any records,
Oh.
but the records really didn't report Dad replying. It was the girlfriend. I don't know, but the
Well,
other
say
person,
anyone
the
in that,
girlfriend.
yeah.
So it was a third party
Right.
who was taking her. So most of the input was not from Dad that I saw when I looked at it. But
Sure.
it's just,
But did the reports
No.
indicate whether or not in that home it's adequately being handled or not? Or
Absolutely,
no,
they
it
do all the
doesn't
time.
really- It doesn't, no one
Alright.
wrote specifics on that, per se.
Do you have any idea then, as you sit here today, how Dad is or isn't addressing this, or do you have an opinion on that, or you just don't know what he's doing?
I don't know, because I don't know that scenario, but I did review documentation of texting and communication for toileting and co-parenting kind of things that Kimberly shared with me, but that would be, and as my perception of what I
Sure.
think.
And with the understanding the court will deal with all this
Yeah.
technical stuff as to who's an expert, who's not, whether your testimony should be considered, all that. If your testimony is considered, is it fair to say with the limitations of you having access to her when she's 3, and then updated records and some information from Kimberly and a few interactions with Aslan, I guess a few, that this is your opinion on with those qualifiers in place, this is your opinion on the potty training situation, but you're unable to say whether Dad's approach is consistent with your opinion, or do you have some insight on that?
I don't have insight
Okay.
on what he actually does and
Okay.
what he doesn't do. I
Okay.
mean, I'll just be really honest that.
Perfect, fair enough.
But what I do believe that Aslan had the ready skills way before now. And was it an opportunity to make this child, you know, for parents, whether it's co-parenting or one individual parenting, there was an opportunity for this child to be potty trained prior to today. And that's just my opinion, and it, I don't know.
You would agree most parents are really, just regardless of the developmental issue, are really eager to get that issue
Yep,
on track as soon as humanly possible.
yep.
Okay, very good. Kimberly has some questions for you. I just wanted to understand her questions within the framework of what
say
you're
that-
doing.
As far as the toileting, you've seen how I've parented Aslan with toileting, and how successful is she on parenting her?
She's very successful in terms of she's eager to go to the toilet. She's praised with being dry. She is not anxious. She did not demonstrate any anxiety with the toileting regime.
And then you also noted that when I did go to put her, or asked about the pull-ups, how did she react being in a pull-up?
Objection, Your Honor. Withdraw.
Thank you.
Okay, so she had, which she did not want a pull-up. When you
She was
offered it
adamant.
to her, do you want to go to the potty or do you want to pull up? She chose to go to the bathroom.
Okay, and again, speaking as to her rashes, which and the various rashes, the rashes from heat rashes and rashes from urine rashes.
Objection,
What
Your
does
Honor.
that indicate to
So-
you?
Objection, Your Honor. Assumes facts not in evidence.
Yeah, well, I was wondering, what's the,
Rashes, all these
what's
things.
the month and year in the
It's also
incident?
leading.
Is this something that's disputed, or is it, what's the offer of proof? What's this
As far as
about?
the rashes,
Yeah, what's this about?
it's well established in the record. Family First has
Okay.
it documented.
You're
I have
referring,
it
I got,
documented
what,
in the-
you're
in the-
referring to what incident, what month and year?
Okay, so when I brought Aslan over the last time, and I showed you
To her?
her rashes, yes, and showed you the history of her rashes.
Okay.
These are pictures I don't wanna submit into evidence
Okay.
because they're of her private area.
Understood.
But, so I submitted them to Yvonne, showing her the weekly rashes that she had every week and what was her opinion on that. And they were consistent. Since I've had her in July, they've been consistent. He even went, and took her to the doctor, actually Carrie took her to the doctor in September 28th and referenced the rashes.
If she
Family First
has a
has referenced the
framework, if
ashes.
that's sufficient framework for her and
Okay.
she knows exactly what
So
you're
the
talking about.
history
So-
of rashes, what does that?
So
your opinion?
rashes can occur when, I mean, it's just like when they're an infant or a toddler and they're in diapers. Rashes occur with people when they're in contact with urine or feces. And oftentimes, some of the heat, when kids are older, they're more active and they're out and about, you can get heat rashes from the use of a diaper or a pull-up, and we see them, it's not uncommon. And then you can, if Aslan is, if a child is not drinking enough fluids, then the urine is more concentrated. And so therefore, if there's urine in a diaper or a pull-up, the concentrated urine then can also increase more of a rash. So that's, that's from knowledge and experience and being a mother.
Okay, and your opinion is of when a child has a rash and in diapers, how does that affect her development in other areas of her life?
Well, I think she's gonna be, I mean, in my opinion, I think it's more focused on the fact that when her peers may be toilet trained and she's not, and she's diapered, then that is an impact on her self-esteem as she moves forward.
And how does that affect her developmentally, though, like in other areas of her life? So developmentally.
Well,
with her
she
growth
might
mode,
be
her
more
fine motor.
anxious, she might withdraw, she may not wanna participate in a lot of activities because she doesn't feel comfortable or different.
They might
So
not.
you agree that this toileting issue is one of great importance, and two, it affects all aspects of her life. and
Well,
development.
it affects all aspects of life, and honestly, it's a life skill that needs to be accomplished, and it's one that's gonna have to be addressed for a very long time, because it doesn't happen overnight. Even as a teenager, she might consistently have accidents
Right.
based on her her special
Based on
needs.
what you've seen from
Mhm.
her, and what you've seen with me parenting her, in your opinion, was she capable of being potty trained out of pull-ups and diapers by the age of 5?
Yes. Yes.
Okay. Now, Mr. Friedman, I'm sure you have questions, but you already made a complete record of the expert issue. The court's gonna deal with that. The court even has some observations of its own on that. So, but if you have questions on this potty training, or it keeps coming back around to what your client knows or doesn't know, and whether he's consistent with what he should be consistent with, or whether he's, there's a lot going on here. This would have, if this witness, if it's valid for this witness to testify, the court would have to make findings that this is really by far the most viable, preferable method, and that your client somehow refuses to adequately potty train. So against that, and I won't know that till he's on the stand, but against that backdrop, you have questions for the witness?
Just to clarify something you said a moment earlier, you testified that in fact, I don't want to put words in your mouth, but somebody, even with best efforts, the process takes a long time, correct?
Yes.
And you testified that even into her teenage years, were it done correctly, she might still have accidents and still need to be prompted and work through the process of toileting appropriately. Is that correct?
Yes.
Okay, we made it. Before he goes any further, we're good for the day. He's an idiot. He is an idiot for talking at all right now, because she in no way made the connection of dad refusing to potty train with this expert. So the expert has nothing to do with anything. She did not connect the father to anything. So this lawyer doesn't have to say anything. This lawyer should not say anything. This lawyer should shut up right now, but he's not going to. We all know he's not going to. And this lawyer right here is going to make that stupid connection for her. I wish I could stop it before it happens, but I can't. I would have just sit back and said, no, I have no questions for this person, and it would have been over. But this lawyer wants to talk. Yeah, but no, because there's a possibility that you could connect the father by asking that. Nope. I did not watch ahead. I don't have time to cheat. I don't know what's going on. I don't even know what happened yesterday, so there's no way I know what happens tomorrow. Trust me. All right, guys. I'm going to potty train myself, and then I'm going to start O.J. Simpson. So hopefully we see like a couple of you there. If not, I will see you tomorrow. Thank you so much for coming out today, guys. Thank you. This is great. Yes, O.J. Simpson. Yes. See y'all in a few minutes, guys. Thank you.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. was no